What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is the mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God!
Everything that guy just said is bullshit. Thank you.
How dare you?
Hey, everybody. Good morning, good afternoon, good evening, good night, wherever you are, whatever you're doing, whoever you're doing it with, however good it feels, and why ever you're doing it in the first place. It's me, and I'm glad you're doing it here with me on my channel, Legal Vices. That's what we're here for. We are here to kind of bump things up a notch here. Look a little more in depth into things than other people might, or that some people might feel comfortable with. But that's what it's all about here. We are having a good night so far. We started on time, so that's a major accomplishment right there. But what I want to do tonight is we've gone through the motions. Megan Fox was on here the previous over the Thanksgiving Day weekend, the U.S. Thanksgiving Day weekend. We were looking at the motions filed by the defense, the long, lengthy motions followed by the defense, and also the shorter but still lengthy attack on juror number 1 and seeking a new trial based on the alleged misconduct of juror number 1. If you saw that, you know how I feel about that. The main thing being we didn't hear about any misconduct from juror number 1. We heard a lot about what his wife did. We heard a lot about what Jules did. We heard a lot about everything other than what juror number 1 was alleged to have done. It was a stupid motion. It was a ridiculous motion. They should feel ashamed of themselves for even filing a motion like that. There's so many different ways they could have handled that, but they chose to go that way. And I just think as a lawyer on a professional level, it was uncalled for. It was unnecessary. It was low. It was icky. That's a term of art. That's a particular legal term. It was just icky. And you know, as I said the past few streams where we've talked about this, the hospital has a right to a defense. That's their lawyer's job. Their lawyer's job is to do everything they possibly can to the utmost of their ability and skill to represent their client. They have every right to file motions for a new trial. They have every right to file motions to set aside the verdict. They have every right to have a motion to renew the directed verdict motion. They have every right to seek for reduction of the damages. They have every right to exhaust all of these legal avenues. But having the right to do something and doing something and the necessity of doing something, they're all different things. And at the end of the day, I still have to be able to look at myself in the mirror and like what I see, like what I've done, and fully approve of everything I've said and done throughout that day. And, you know, turning your gaze towards a juror and attacking a juror the way they did with juror number 1, going after juror number 1, the allegations they made against him, and then in the amended motion, the supplemental motion they filed, where they went after past records, that was some low, dirty stuff. I would be asking for sanctions for that one if that was me, because I think it's just again, icky is the word I got. I got nothing else better than icky to go with. So we're going to look at the plaintiff's response to the motion to set aside the renew heaven. Sorry, I've got myself all worked up already at the very beginning. We're going to be looking at the plaintiff's response to the defendant's motion for a new trial based on juror number 1's misconduct. We're going to go through that. It also is 124 pages, but most of it are the appendix and the additional items. The memo itself, I think, is around 27 pages, and there's a lot of other stuff there. We've got the dogs making noise over here in the corner, so if all that you can hear is, if you're a regular viewer, you'll know that is Strawberry, who is choosing to eat her bone on the single most inappropriate place in the house, which is a hollow piece of aluminum sliding where the veranda door slides. So bear with me. When I can't handle it anymore, then I'll go and stop it. All right. Let's see. We got a couple of super chats to start us off. Thanks, everybody, for being here. Wait a minute. How come only one of these is coming up? Oh, it's a double message. How nice. Right. We started off with Jeremiah Jordan. Thank you so much, Jeremiah Jordan. I've been watching this case gavel to gavel. It's heartbreaking to watch, but JHACH is in the wrong, even though they're a client of mine. I think they're. Well, the jury decided that they were in the wrong. And of course, we all have our own opinions. Mine happens to be they were also in the wrong in a great many ways. But I think the people that are really, really in the wrong right now are the lawyers for JHACH. I think they're the ones that have to worry about this. They're the ones that have to live with what they're doing. And I couldn't do that if I was them. The way they went after juror number 1, I couldn't do that. I just simply couldn't. All right, I'm getting pre-agitated. I'm getting pre-agitated. There's enough to get agitated about. I don't have to agitate myself before getting agitated, but give me just one quick super second here. Strawberry's already annoying me with the chewing on this pad here. Hang on. I should have cleared this up before. I'm sorry. Give me 1 second. Okay, I'm back. English Bulldogs literally do nothing 23 hours and 49 minutes of the day. The only, the 11 minutes these dogs are active is the first 11 minutes of a stream of mine. All right, so I'm back. Sorry about that, everybody. While I was gone, I see we got a super chat from Hippo Lover. Thank you so much. Thank you so much for the super sticker, the $4 super sticker. Thank you so very much for being here. We're going to be talking about this today. So, I hope we do this thing justice, because we're here today, and we're talking about plaintiff's response to defendant John Hopkins All Children's Hospital motion for a new trial based on juror misconduct, motion for juror interview, motion to open discovery into evidence of juror misconduct, and emergency motion to preserve evidence. Let's bring the document up and start going through it, because we got a lot of ground to cover and our limited amount of time to do it in. I don't want the main part of this to go over into a second stream. We might look at some of the exhibits as part of another stream, but I want to get through the main body today. All right, let's embiggen this as much as we can. I'm sorry to take your bone, doggy. All right. We can make that slightly larger, I guess. How's that? One more? We can get one more out of it? We might even be able to get one more. That's too much. Great. Roll out one, or is it? All right. Well, that seems to be it. Yeah, that's a little too big. Kind of annoying. All right, there we go. Let's just do this. Let's roll with this. See. Again, if you want to see my comments with Megan Fox about the defense's original motion, go back and watch those. They were done just a few days ago. And before we get going, let's do these two super chats that just came in. And then we'll do the super chats in batches at natural breaks in the motion. The first super chat that just came in is Unhung Hero. Thank you so much, Unhung Hero. $2. Juror number 1, have a defamation case versus Johnny Depp's kids. John's drop kids. Sorry. How did I see Johnny Depp's kids? I was like, what? It's been a day. Juror number 1, have a defamation case against John's drop kids. Unfortunately, no. But there could be sanctions for the lawyers, especially if they double down. They've got an option now: back off or double down. If they double down, it might not go so well for them. And Dan Bennett, thank you so much for the $10 raid from LC. Hi, mate. Hey, thank you, Lincoln Kane, for the raid. Deeply, deeply appreciated. Welcome, all you Lincoln Caners. Everybody, please, while you're here, hit the like and subscribe button. And we won't harp on that too much, but I do have a like and subscribe poll for the 464 of you that are here so far. That's going to increase, I hope. We've only got 169 likes, so like 300 of you haven't done your job. 3/4 of you just get down there and smash that like button and take our like and subscribe poll. The like and subscribe poll today is: what is your opinion of the Maya Kowalski lawsuit judgment against JHACH? She deserves compensation. Her claims are unfounded. Both parties are responsible, and there's not enough zeros. We'll check back in about an hour or so and see how you've all chosen to answer that question. But like, subscribe, and take care of that. With that out of the way, or with a $5 super chat, said Lincoln Kane said, "Yo." All right. Hey, yo, right back at you, LC. Thank you, brother, for sending your peeps over this way. All right, we're going to get into the motion. The next time we'll look at the super chats at the next logical break. So plaintiffs Jack Kowalski, individually and on behalf of his child, Maya Kowalski, a minor, and his personal representative of the estate of Beata Kowalski, deceased, collectively plaintiffs, by and through undersigned counsel, hereby files its opposition to, we're not going to read it, files their opposing motion. We won't read through the whole title again. The argument, the motion, which really should be titled Jury Misconduct by Proxy, should be denied in its entirety for the following reasons. That is a great way to start this off, because that's as Greg Anderson said, this is just jury misconduct by proxy. I love that. I mean, if there was any way that he could actually officially title this document that would have been a perfect title. A defendant failed to preserve its juror number 1 challenge. Okay, first of all, I already love this motion because it tells you right out of the gate in one sentence, this is the problem. Right there in the title, this is the problem, not here's the issue, this is what we're going to look at. This just tells you, this is all he needs to say. Defendant failed to preserve his juror number 1 challenge. The rest is fluff. The rest is filler because that accurately states it. Besides asserting an incorrect standard and basing its allegations on asserted posts of people other than juror number 1, defendant failed to preserve the arguments it now makes after the verdict. The pre-verdict information on which defendant relies was available, and it appears known to defendants before the verdict. Yet defendant waited to see how the verdict came in before bringing these assertions to the court. Had it acted timely, if its claims had any merit, they could have been addressed before the 9-week trial went to the jury. Absolutely spot on. Use it or lose it. If you've got a challenge, you need to use it when you know about it, not when it's too late, not when things don't go your way. Over 20 years ago, the Florida Supreme Court stated the court system is already overburdened and does not have the luxury of allowing jury verdicts to unravel or be subject to attack because of information which could have been reasonably obtained before the trial begins. The same rationale applies to information that could have been discovered during the trial, when an alternate juror could move up to deliberate. In 2002, the court said in a perfect world, access to the information would be immediately available in all courtrooms or actually provided as jury pool information. Because of advances in technology, that day has arrived, and it may be appropriate for the courts to revisit whether parties have a duty to investigate juror backgrounds before verdict. But the court need not reach that issue. The court doesn't even have to go that far. The court just has to see that the defendant failed to preserve its argument. Well, the defense bases its motion largely on internet posts during the trial, as noted below. That was like during the trial, not juror number 1, They don't say during the trial, juror number 1 did this. They said juror number 1, whose wife happens to be here in chat. We saw the super chat from Hippo Lover. Juror number 1's wife did this. Not even juror number 1. That's where we get this juror misconduct by proxy. So they're basing it on internet posts that happened during the trial, as noted below, to the extent it refers to alleged communications after the trial. Jurors, and this is the one thing we harped on, jurors are free to discuss their service when the trial is concluded. That's the two big takeaways we took from the defendant's motion. One, the jurors can do whatever the hell they want, basically, after they're no longer a juror. After the trial is over, they are free to say, do, or whatever, talk about whatever they want to talk about. And two, again, the whole thing was, what did Jules do? What did juror number 1's wife do? They were never under oath. They were never under a court order to do something or to not do something during the trial. They are not jurors. They're free to do whatever they want. They're free to discuss what they want. We have that little First Amendment right to do that. Those materials were available to the defense in real time. Defendants claims it strains credulity to believe juror number 1 and his wife were not communicating with each other during the trial. Defendant is wrong. First, the court told the jurors repeatedly that they were not to discuss the case with anyone, even family members. As noted below, to engage in an unsupported assumption, defendant posits would mean there could never be a married juror. Example, they're saying, well, they lived together, they spent their time together, they weren't sequestered, they probably even slept together. So there's no way they couldn't have talked about the trial. Again, that's the one thing we talked about. How do you sequester them or drop this silly argument? What? I mean, really, they're just saying that anybody, if you live together, clearly you're talking about absolutely everything with that person. That was the insinuation. They're living together. They couldn't help but talk about it, especially because one was on the jury and the other was interested in whatever it was her husband was doing or the trial that was surrounding it. So yeah, they're saying that if we go by the standard that the defense has set in their jury misconduct motion, then there can never be a married juror, because we would just have to assume that because they live together, they're talking about it. And that is the exact opposite assumption that the law makes. The law makes exactly the opposite, 180-degree assumption from there. So it does not strain credulity to believe jurors follow instructions. That we have the assumption, we make the assumption, and I believe it's mentioned later on in the motion. That is the base assumption. You assume that the jurors fulfilled their oath unless you have evidence that they didn't. Unless you have evidence that they violated that motion, that order, that oath they took, you must assume that they fulfilled it. And what we saw with the motion wasn't, here is the evidence that we have that juror number 1 committed misconduct. There wasn't any of that really in the original motion. What they had in the original motion was they lived together, he was on the jury, she was posting about it and watching it, so therefore they must have done it. We think there's a good probability that they did, so we want to bring juror number 1 in and investigate him and go on a fishing expedition to see what information we can drag out of him, because we think there might be something there. That's not enough. Second, as discussed below, evidence shows the defense counsel was actively engaging with members of the public through the internet during the trial. The rabid Redditors who were so happy with themselves. They were actively engaging with members of the public through the internet during the trial, and therefore all the pre-verdict posts defendant complains about in the motion should be considered known to the defense team before the verdict. Defendant has not denied it knew about these posts in the motion, and if it does, the members of the defense team should be placed under oath and questioned, but that shouldn't be necessary. Where a lawyer knows of an incident potentially compromising the jury before a verdict is returned, but fails to object or alert the court until after the verdict is announced, the incident may not be raised as a ground for a new trial. That right there, it's a case from Florida case from over 20 years ago, lays it out right there. If you know of a potentially compromising jury action before the verdict and you don't object, you don't alert, you don't take action on it until after the verdict, you lose your right to bring it up again. It's done. The second district holds the same. When it was discovered during deliberations that the bailiff had left the judge's copy of instructions with changes made during the charge conference in the jury room, the defendant's objection was untimely because it was not made until after the jury had delivered an adverse verdict. Yeah, see, if all of this would have gone wrong and it would have gone against, if the jury would have come back with a verdict for Johns Hopkins or a hung jury one, they probably wouldn't have made these complaints. No, they just waited until they lost, and then they tried to backtrack and fill it in with all of these other assertions. In sum, defendant's erroneous argument is not preserved. They did not preserve the matter for appeal because they didn't bring it up when they knew about it during trial before the verdict. What if you're a single juror that plays the field? Well, then you can't talk to anybody because you don't even have the one person you can shack up with. All right, this is a logical place to read the next round of super chats before we get too far behind, and we'll just give a big foghorn thanks to all of the super chatters. Thank you so much, everybody. Dan Bennett, go org, my brother. LC gifted 5 Legal Vices memberships. Lincoln Kane, thank you so much. If you got one of the Lincoln Kane gifted 5 Legal Vices memberships, give LC a big shout out and a thanks. Thank you so much. And Dan Bennett again from the lovely Shani and LC. Oh, thank you so much, Shani. Shani is LC's partner. Thank you so much. And Dan Bennett again from the lovely Trish and Karen. Hey Trish, hey Karen, thank you so much. And LC with another fitty. You get a special foghorn for that. Stay calm and do some whiskey, bro. Ayo, let's go. I don't know how calm. I'm trying to stay calm, but we can do a cheers for you. Cheers. Thank you so much, LC, for the generosity. And for sending your peeps my way. And from LC and Terpy. Hey, Terp, it's been a minute. Thank you so much. And LC gifted another 10 Legal Vices memberships. Thank you, sir. If you get one of these 10, give them a super shout out and welcome. We'll be doing a members only stream here in the near future. But thank you so much for all the generosity, guys. We will jump right back into this. B, defendant has not. So the first argument was they didn't preserve it. They knew this posting was going on. If they thought it was a problem, they had to bring it up when they knew about it during the trial before the verdict. If you wait to see how it turns out and it goes against you and you go, okay, now I want to complain about something I knew before, too late. It's not preserved. Done. I agree 100% with the analysis by the plaintiffs in this case, and there shouldn't be a need to look at anything else. Too late. You lost. Done. Well, maybe we'll get the double guns. Is this what you're saying? Is this your argument? Is this your argument defense? Yes. Denied. Hopefully we'll get that because that's what needs to happen. Defendant has not presented legally sufficient prima facie. Prima facie means on the face of it. Just looking at the face of the documents, looking at the face of the arguments. Have they presented evidence of misconduct of juror number 1? That's exactly what we were just talking about. Everything is about what juror number 1's wife did. Everything is about what Jules did. Everything is about, the Jules was close to the Kowalskis and became juror number 1's. It was either juror number 1's wife or Jules became friends with the sound tech guy or something. It was ridiculous. None of it went back to misconduct by juror number 1. So they're saying they're just looking at the face of the document. There is no evidence. There's not even a basic first glance look to say, oh, there might be something here. The correct legal standard for a juror interview, because that's what they want to do. They want to bring in juror number 1 and possibly his wife and interview / interrogate them about everything so that they can see if there's something there, if they can catch them on something. So what do they need to do? What do they need to show to bring them in for an interview? That's what we're looking at here. That's what's going to be considered in this section. In Baptist Hospital of Miami v. Mahler, and I see this quoted in a lot of places. So this is probably a seminal case. The Florida Supreme Court set forth the showing that must be made before a trial court can permit a juror interview. In doing so, the court emphasized the, quote, strong public policy against allowing litigants either to harass jurors. This is in a court verdict. I mean, this is in a court judgment. there's a strong public policy against allowing litigants either to harass jurors or to upset a verdict by attempting to ascertain some improper motive underlying, and held that an inquiry is never permissible unless the moving party has made sworn factual allegations that, if true, would require a trial court to order a new trial. The court stated, quote, "The case law on this topic allows of the fact-finding process inquiry only into objective acts committed by or in the presence of the jury or a juror that might have compromised the integrity." Now, because defendant's motion contains no objective acts that were committed by or in the presence of juror number one, defendant has failed to carry its burden. Again, I cannot agree more with that. What they're saying there, it's not even, we can see, S. Mountain Man says receipts would be nice. It's even more than receipts. If they came forward and said, okay, this is what we have. We have juror number one's wife talking to juror number one about this, or here is evidence of juror number one himself on a social media platform saying this specific thing during the trial. We've got a whole different argument, but there is none of that. It's all saying, his wife did this, Jules did that, this other person went this, they took pictures with this person, so therefore he must also have been aware of it. There's that break. There's not this linear progress from them to him. There's a break in the action somewhere where they're fishing to try to find that link. This motion supports the request to interview juror number one solely by inferring, the motion, not this motion, sorry. The motion supports the request to interview juror number one solely by inferring that he has violated the court's instruction based on the conduct of his wife and others. In effect, the motion asks the court to impute the actions and statements of juror number one's wife and others to him, misconduct by proxy. So their action, they made the statement that his wife was effectively acting as his agent. That's a bullshit argument from square one. There's nothing to indicate that he appointed her to be his spokesman or to make statements on his behalf. It's fantasy. Merchant v. State involved a similar attempt to use assumptions and inferences to conclude that jurors had violated the court's instruction not to discuss the case. Well, what happened in that case? There, the trial court became aware during jury deliberations that a brother and sister had served together on the jury until the brother, the alternate, was discharged. How do you not catch that? How do you not catch the two people on the jury are brother and sister? How does that happen? Okay. But anyway, so we got a brother and a sister together on the jury. The trial court, sua sponte, that's the court on its own authority. Just sua sponte is the court, just on their own authority, the court declared a mistrial. The court stated, I can make a presumption they are brother and sister, and I found they have driven back and forth together. They must be talking about this. So the judge went the way that the defense in this case are going. They're like, hey, they come back and forth together, they're brother and sister together, so they must be talking about this. Mistrial. Well, that was appealed, and the appellate court disagreed. The appellate court told the judge it was wrong. The trial court's decision to declare a mistrial without the consent of the defendant appears to have resulted from a series of assumptions and inferences rather than from competent record evidence. Now, see, if you recall watching when I was reviewing the other motions with Megan, I was getting on the defense for the bold and underlined statements. They're different here. They're using bold and italics to point out the fallacies, the problems with the defendant's arguments. They're highlighting. They're using them for highlighting purposes. In the defense's motion, all of their italics and their bold and their underline was designed to ramp up the rhetoric, to ramp up the emotions, to point out things that may possibly be linked to something. So the bold and stuff I was getting angry at the defense over is different than the italics and bold that the the plaintiff are using here, because they're using it strictly to emphasize the legal points in their favor. So don't call me a hypocrite on that. All right. This judge that declared the mistrial without the consent of the defense appears to have resulted from a series of assumptions and inferences rather than from competent record evidence. Even if we're to accept the assumption, even if we accept that Kira and Kevin are brother and sister, this surely did not, without more, necessitate a mistrial. There is nothing in the record to indicate that Kira and Kevin heard the trial's court's request made to the veneer, that's like the entire panel of jurors, at the commencement of the jury selection process for jurors to notify the court if any prospective jurors knew each other. There is no evidence in the record that Kira and Kevin discussed the testimony or evidence with each other, or otherwise violated the trial court's daily admonitions to the jury. To the contrary, the trial court began each day of the trial by confirming that each of the jurors followed the court's instructions not to discuss the case with each other or anyone else. The trial court also ended each day and prefaced every recess by reminding jurors of this instruction. Now you know why every single break when the jury leaves, he runs by, even if it's going to be like a 5-minute walk down the hall to take a leak break. Don't discuss the case amongst yourselves. Don't form any opinions. Don't read any outside stuff. That litany that the judges go through. Then when they come back, they check whether or not that happened. That gives the jurors the time right then and there to say yes or no. They do it at the end of every day. They do it at the beginning of every day to make sure that this box is checked. And it covers the grounds for appeal. So thus, the only information that the trial court had before it was a statement from the bailiff that Kira and Kevin were siblings, and that Kevin, having been discharged as an alternate juror, was waiting outside the courtroom to drive Kira home. This alone was hardly sufficient to warrant a mistrial. Hey, what's up? Let's go. Brandon, is Valhalla Waits hiding in here? I don't know. I haven't seen Valhalla Waits hiding in here, but I see you hiding in here. and hey, up to you, Project Metal Music. Good to see you here. So, and they tell us they've added the emphasis. The emphasis wasn't in the original jurisdiction. They added the emphasis to point it out. Exactly, Melanie. And that's what we've been harping on this entire time since the defense started filing the motions. The juror number one's wife isn't even a juror, so the rule doesn't apply to her. Yeah, she's never put under oath. She's never told not to do things. A motion seeking to interview jurors is based on merely conclusory statements based on speculation and surmise. And this is what they're trying to do. They're speculating that juror number one and juror number one's wife had these communications. It's pure speculation right now. They speculate, and they're hoping that if interrogated, the jurors might have something to say that would be material to whether or not the court should award a new trial. That is insufficient. A motion for interview of a juror will fail where there was no suggestion in the record of any misconduct or irregularity on the part of any juror. Here, juror number one's wife, and this is what we were just saying, here, juror number one's wife did not serve on the jury with her husband. And there is no reason to assume juror number one disobeyed the court's instructions not to discuss the case with anyone merely because he has a wife. I used to have one of those, a wife. And I can pretty much tell you that we didn't listen to a thing the other person had to say the vast majority of the time, which is why I don't have one of those anymore. Oh, dogs. They found another. I'm so sorry. This is embarrassing. Got a plastic bottle to take care of. Hang on. Sorry. Oh my gosh, how embarrassing. That's twice. They're just finding every little noisemaker they can. All righty, sorry about that. Apologies again. Well, I'm sorry, baby. You can chew on it later. All right, well, that kind of centered me. That's brought the blood pressure down a bit. That's good. That was a little palate cleanser. All right, here, but it's going to go right back up again. Here, juror number one's wife did not serve on the jury with her husband, and there's no reason to assume juror number one disobeyed the court's instructions not to discuss the case with anyone merely because he has a wife. As I was saying, I used to have one of those. We didn't listen to each other. You know, it's like the Bill Burr tells the joke of, Your spouse is like, and then you just kind of like, you're like, and then you go, oh, that's a question. Uh-oh. That's kind of how it is. And interests are different. And plus, they've taken an oath. We assume that if for some reason he went rogue and started talking, she should shut him down. Or if she started saying, hey, here's what I heard about the trial, we assume, unless we have evidence to the contrary, that he says, wait, stop, don't talk to me about that. That's what we have to assume. Defendant acknowledges. So this is a defendant's what is the defendant acknowledged? Defendant acknowledges through the motion that it has no evidence juror number 1 violated its oath. They quote, this motion sets forth a reasonable basis for belief that juror number 1, the foreperson, engaged in presumptively prejudicial misconduct. For belief. It doesn't say this motion sets forth a reasonable basis for concluding or for showing or for proving. It says for believing. It's a mere belief. And that is not enough. Let's see. The juror number 1's spouse's social media posts highlighted her heavy personal bias in favor of the plaintiffs, a bias that the defense says apparently shared by her husband. It strains credulity to believe that they were not discussing the case in violation of this court's instructions. Those are not objective acts committed by or in the presence of juror number 1 as required by the Mahler case. I don't even need to comment. Notice how much padding and bullshit there was in the other motions filed by the defense. This, although it's 20 some odd pages long, is a very streamlined motion. There's not excess fat in here. This is a lean, well cut, well written, straight to the point motion. They get it. The plaintiffs get a 10 out of 10 already, and we're on page 7 for just the way this motion is written. Oh, we have a Megan Fox sighting. Megan, are you here? Hi, Megan. In the conclusion of the motion, defendant again acknowledges it has no evidence of actual misconduct by juror number 1. And here's what the defense said. This is the defense's own words acknowledging that they have no actual evidence and that they're just on a fishing expedition. It strains credulity to believe that juror number 1 and his wife were not sharing information regarding the case, particularly given the nature of their social media participation. Defendant does not have to prove actual misconduct to be entitled to a juror interview under Florida law. Rather, defendant only has to establish a reasonable belief that misconduct occurred to be entitled to an interview a juror regarding presumed misconduct. The circumstances here are very different from those in the authorities cited in defendant's motion. In Amazon v. State, the trial judge learned of multiple undisputed instances which are objective facts where sequestered jurors had violated the sequestration order by spending time together in a bar, having dinner with a third party, as well as 2 jurors watching a news account of the trial on television, albeit with the sound turned off. That is an objective act in violation of their juror oath. That's clear cut. Following which, one juror remarked to the other that a state's witness testimony had been impressive. That's a little different than what we've got here. That doesn't even come close to what we've got here. Likewise, in Norman v. Gloria Farms, Inc., the plaintiff learned the undisputed fact that the jury foreman's brother was an employee of the defendant's insurance carrier. Okay, we talked about that case a little while ago as well. Defendant has cited no cases, and plaintiff is aware of none, where a juror interview has been based on inferred conduct of a juror or conduct of a third party imputed to a juror. Again, they hit the misconduct by proxy. This is a misconduct by proxy motion. That's the second time they've hit that. And that's what a good motion does. You tell them again, and then you tell them what you told them twice. That's how you want to hit those points. You want to hit the talking points. Boom, boom, boom. Tie it all together in a nice, neat package that resonates with the judge. Just think, and you're going to see it. You're going to see it tomorrow on the stream. Tomorrow or next Thursday on the O.J. Simpson stream that Chandler Remington and I are going to be doing. We're going to be watching the closing arguments in the O.J. Simpson trial. And when you hear Johnny Cochran say again and again and again, if it doesn't fit, you must acquit. If the glove doesn't fit, you must acquit. If it doesn't fit, you must acquit. You hear that again and again and again, and it gets in your head. And here he's just hitting out. Remember, this is misconduct by proxy. This isn't misconduct by proxy. Hits another point. Misconduct by proxy. Keep that in mind. 2, the legal standard for a new trial based on alleged juror misconduct. Well, before we get onto that, let's go through the chats that we've got lined up here. Again, a big super foghorn for all of you that are supporting us here. Thank you so much. From Alan. Thank you so much, Dan Bennett, for sending things from Alan. Thank you. And David Knight says, legal vices. Have you ever seen a lawyer lose the case because of their wife's been on social media? No, but I think we've established that Shapiro's wife was lurking around Reddit, so maybe there has been a case where a lawyer lost a case because their wife was on social media. Speculation. Stingy, did you discuss the case with anyone? Juror, I whispered sweet testimony details in your mom's ear at night during the trial. Oh my God. That's actually funny, but okay, didn't see that one coming. Oh, I get too serious. That's why I need Megan here. I get too serious. This is actually a hilarious motion, but I'm getting angry. I believe in Teletubbies. Does that mean they're real? But they're not? No. Next, damn it. Thanks, Matt Bond. Spoilers. Megan Fox, what's up, girl? How's my favorite Lorax this morning? Here's some dollars towards the Hound Cam. Love you, Jeff. Oh, are we doing Doggo Cam? Are we unleashing the Doggo Cam Hound? Wait, the Doggo. Are we unleashing the Doggo Cam? Are we releasing the Hounds? I'm not sure. I'm not sure if this is a serious motion. Do we need dogs? Should we unleash the Doggo Cam? Because we're there. One if you want to see a dog, two if you don't. Throw that up in the chat here. And let's go, Brandon. Says, my wife is on a murder trial and hasn't even crossed my mind to ask her about her day. May need to retain TLA. Looks like we want Doggo Cam. There's literally no twos. All right. Well, we have reached the level to do that. Let's quickly bring up my who do we have today? We've got Strawberry. Strawberry's on cam today. Let's see. Just quickly set this up. We weren't expecting to have a guest today. And there we go. There's Strawberry. Strawberry's just there, minding her own business, sitting on her chair on the veranda. Okay, welcome, Straubs. Thank you so much for everybody that got us there.
Release the hounds. It
happened. Yes, retain the lead attorney. Anyway, sorry, that's my little inside joke there, but it's not really inside. Anywho, let's get back into this. Thank you so much for the support, the continued support, guys. Love all of you, and it's just great to have you here. And as long as we okay, I was going to do the midstream grip, but we're far away from it, so I'll just keep my mouth shut and move along. 2, the correct legal standard for a new trial. And again, that's a sneaky little slap. That's actually a sneaky little backhand to the defense right there. Ordinarily, something like this would say, the legal standard for a new trial based on alleged juror misconduct. They threw in that the correct legal standard. That's just a little knock at the defense for putting out the wrong legal standard. Kudos for that. Kudos for that subtle little. That was just slipping the stiletto between the second and third ribs. That's nice. the correct legal standard for a new trial based on alleged juror misconduct. The motion also states that potentially harmful juror misconduct is presumptively prejudicial. Potentially harmful juror misconduct is presumptively prejudicial, citing Amazon. This is an incomplete, what did they leave out of those ellipses? There must be something hidden within the ellipses that would change the story. This is an incomplete and therefore incorrect statement of the standard to determine whether alleged juror misconduct, if established, requires a new trial. In Amazon, the defendant argued that the undisputed evidence that jurors had violated the sequestration order placed the burden on the state to refute a presumption of prejudice raised whenever a juror misconduct is shown. Let's read that again. The evidence jurors violated placed the burden on the state to refute a presumption of prejudice raised whenever juror misconduct is shown. The Florida Supreme Court disagreed, stating that the position urged by the defendant is not the rule in Florida, as one of the cases cited by Amazon explains, if the misconduct is such that it would probably influence the jury. If the misconduct is such that it would possibly influence the jury, and the evidence, and these things, and is an important word. That means both of these must be met. It must be such that it would probably influence the jury, and another requirement is the evidence in the case, the evidence in the cause is conflicting. The onus is not on the accused to show he was prejudiced by the law, was prejudiced for the law, presumes he was. Okay, so he doesn't have to show it because the law presumes it. But it should be clearly understood that not all misconduct will vitiate a verdict, even though such conduct may be improper. So improper conduct does not in and of itself throw out a verdict. It is necessary either, so this isn't both, this is one or the other. It is necessary either to show that prejudice resulted or that the misconduct was of such a character as to raise a presumption of prejudice. All right? It either has to be prejudicial. Prejudice has to have resulted from the juror's action, not the juror's wife, not somebody that said hi to the juror in the hallway, not someone that took a picture with a juror, not someone who texted a juror. It's the juror's misconduct. Texted a juror after that case. It's necessary either to show that prejudice resulted from the juror's, or that the conduct was so bad that it just raises a presumption that prejudice occurred. In other words, potentially harmful misconduct is presumptively prejudicial, but the defendant has the initial burden of establishing a prima facie case that the conduct is potentially prejudicial. So the burden is not on the plaintiff to prove that there was no prejudice. The burden is on the defense in this case to show that there was, at least on the face of it, at least at first glance, that the conduct was potentially prejudicial. In order to constitute juror misconduct and therefore a matter extrinsic to the verdict sufficient to set aside the verdict, or for a post-trial inquiry, Florida and other courts have consistently held that some objective act must have been committed by or in the presence of the jury or a juror, which compromised the integrity of the fact-finding process, as where a juror was approached by a party, his agent, or attorneys. And they keep harping on this idea that you need an objective act by the juror or in the juror's presence, none of which was shown in the least in the motion by the defense. They got the citations here. And the new trial ultimately ordered in Norman was based on the objective facts of the juror's familial relationship with an employee of the defendant's insurance carrier who had participated in the investigation of the subject accident and the actual conversations about the case between the juror and his brother. So again, there was this objective act. One was the guy worked for the defendant's insurance carrier and he discussed the case with the juror. Defendant has proved no authority and plaintiff knows of none where the prima facie case of prejudicial conduct required to order a new trial is established purely by inference or imputation of the conduct of others to the juror, i.e. misconduct by proxy. Now, every section ends with misconduct by proxy. It does not fit, you must acquit. Keep hitting it, keep hammering it. Nikki McCormick says, Hippo lover, my thoughts are with you and your husband. I hope you are staying safe. The defense is they're throwing a dry turd at a wall and seeing if it sticks. I was going to go with the spaghetti defense, but that works too. That works too. Oh dear. Right. So the second argument here, the record regarding juror number one's conduct or lack thereof. Ooh, let's look at the record. The record regarding jurors number one's conduct or lack thereof. I think we're probably going to be focused more on the lack of juror number one's conduct because there was none mentioned in the there was nothing objective, there was nothing substantial mentioned in the motion by the defense. Like all jurors, at the beginning of trial, juror number one took the oath to inter alia, or among other things. I know legal Latin. So inter alia means among other things. The juror number one took the oath to, among other things, follow the instructions of the court. At the beginning of the trial and at every break thereafter, this is what we were just talking about a minute ago, the court instructed the jury to refrain from speaking to anyone about the case, from doing independent research, and from forming opinions about the case prior to their deliberations. On each occasion, when proceedings resumed, the court asked whether the jurors had followed his instructions, and juror number one always answered that he had. Florida recognizes a presumption that jurors will follow their oath. That is the important thing that we were talking about near the beginning. You presume the jurors are following their oath and abiding by it unless you have evidence to the contrary. Remember, after the Johnny Depp Amber Heard trial came out, what was the first thing that Elaine tried to do? She just gave it a whirl and tried to show, she tried to throw the jury under the bus. So the jury had to, we had these breaks, we had these long breaks, they weren't sequestered, we had these long weekends, we had this several weeks long break for whatever, this judicial conference or whatever it was. They had to have seen it. They had to have done this. She said that without evidence. And she took some serious flack for that. She tried to throw the jurors under the bus, saying that they violated their oaths as jurors without a single shred of evidence to back it up, with just they had to have because they had some free time. And she made that allegation exactly one time. She made it exactly one time. And once that backlash hit, she shut that shit down quick because she realized that she can get in trouble for alleging stuff like that without the evidence to back it up. That's a very, very dangerous path to go down. Quick Bite says, I'm trying, Your Honor. Elaine, do or do not. There is no try. Yoda, the small green Jedi, not the dog. Oh, hey, Rob. What's up? We apparently have Rob in the house. Okay, well, let's jump back into the rage fit here. Where were we? Oh yeah, you have that presumption that they are following their oaths, they are abiding by their oaths, and if you're going to throw the jury under the bus, if you're going to make specific allegations that they are somehow violated that oath, you better damn well have something to back it up, because it could go sideways for you real quick. Like all jurors at the beginning of the trial, juror number one took the, we already read that, so let's don't read that whole thing again. Florida recognizes a presumption that jurors will follow their oath. In the absence, this is from the Low V state, in the absence of evidence to the contrary, we presume that the jurors follow the trial court's instruction. That's the benefit of that we give the jury. That's how we respect them and treat them and show them that we believe they're taking their oath seriously. Unless you can prove it, they're doing it. As stated above, defendant acknowledges throughout the motion that it has no evidence that juror number one in fact violated his oath. Like the motion, the supporting affidavit of defense counsel Shapiro only contains his suppositions and theorizations about whether juror number one in fact violated his oath, and relies largely on the fact that juror number one and his wife are married and they live together. from which he infers that they must have discussed the case. Defendant cites no authority supporting the argument that improper juror communications can be inferred from the fact of a juror being married. That's a good point. There's nowhere in their motion where they say, here is some case law showing that we presume that if the juror is married, that they are communicating about the case improperly with each other. Yeah, there isn't much to show that because it doesn't exist. Indeed, if that were a legally sufficient basis to challenge a verdict, every verdict in every case rendered by a married juror would be subject to a challenge. That is a major point right there. So they're saying that's the imputation. They're married, they lived together during this entire trial, so they must have talked about it. He drops the heat right here. If that were a legally sufficient basis to challenge a verdict, being married and then therefore supposing that they're talking about the case, every verdict in every case rendered by a married juror would be subject to challenge. Again, I gave the format and the writing of this motion a 10 out of 10 already, like 3 pages ago. I'm giving it an 11 out of 10 right now. As I said, this is precise laser writing. It's to the point, it's direct, it's concise, it's fat-free. There's not a lot of pork in this. This is a very, very well written, very well organized, very readable motion. To kudos to the writer of this motion, which I believe was Anderson himself. I haven't actually checked the signature line yet because I just assumed it was him. To the extent to which the motion reaches for any purported factual basis is best demonstrated by the reference to juror number 1's post-verdict. Now, again, we harped on the defense for using italics and bold. But again, they used it to snipe and snark and to do things like that. Here, it's used to point out and highlight something. This is a legitimate use of a bold, italicized post-verdict as opposed to pre-verdict online statement. Oh boy, I'm in trouble again. From the 2 words, once again, the defendant surmises the comment indicates that he knew from conversations with his spouse prior to being released from the courthouse that defendant had moved to dismiss him as a juror. Patently, this is pure conjecture. And once again, the trial concluded there would be nothing wrong with all the jurors learning what went on during the trial that they had not seen. Once the trial concluded, there would be nothing wrong with all the jurors learning what went on during the trial that they had not seen. 1 and 2 syllable words lay it all out right there. Mindy, this is one of my dogs. That's Strawberry. Yoda is in the living room on the sofa right now, sleeping peacefully. They're both English bulldogs. Otherwise, all the matters the defendant contends show misconduct by juror number 1 are matters anyone watching the trial could know. And we did that when we read through the motion with Megan and everyone else I saw, everyone else that I watched that talked about this as well. Rob, I saw you in the chat there. I know Rob did it. Kurt did it. Everyone that went through this motion all said the same thing. I mean, everyone went through the defense's motion when they said nobody other than the juror could. We all called bullshit on that because we were saying exactly the same thing while watching it. We were all reaching the same conclusions and having the same questions that they were doing. So it's a ridiculous assumption. It's a ridiculous statement because we were all thinking exactly the same points. They were accusing juror number 1 of having only knowledge about that because of his wife. It's ridiculous and it's utterly it's shameful that they would put that out there. Defendant has focused its fire against juror number 1 on 3 primary targets: juror number 1 himself, juror number 1's wife, and a member of the public gallery and social media commentator known as Jules. Although the defendant's motion is scattershot, I like that. Although it's not well written and it's just sort of a blunderbuss shotgun approach, and the connections between each of these individuals' conduct and any so-called juror misconduct are never drawn by defendant. Again, that's what I was saying at the beginning. They have juror number one. They have all this conduct going on over here, but there's a huge break in the middle. And they want to suck in juror number one for an interview, possibly juror number one's wife in for an interview, so they can try to build a bridge between what's happening on this side of the chasm and what juror number one is doing over here on this side of the chasm. And that you just can't do that. You just cannot have a fishing expedition like that. Although defendant's motion is scattershot and the connections between each of these individual conduct and any so-called juror misconduct are never drawn by the defendant, plaintiff will address each in turn to demonstrate the absence of any basis to establish juror misconduct. A, juror number one's alleged direct actions. Oh, my sweet baby dumpster Jesus. Questions regarding creature comforts. Blood pressure just spiked. I'm seriously, I literally just felt this flush go down. All right. The most pointed allegations made against juror number one in the defendant's lengthy motion concerns alleged outside research performed by juror number one. Specifically, defendant's counsel claims without basis that juror number one learned of the concept of creature comforts from Dr. Kirkpatrick's RSD Foundation website. But like each of the defendant's other supported claims, defendant has no facts, but only conjecture. First, it must be emphasized that defendant does not stop at one claimed instance of internet research, but broadly claims without basis that juror number one inappropriately conducted internet research on one or more issues in this case. Despite that bold claim, defendant never tells the court or plaintiff what other issues those might be. The only one issue arising from alleged internet research specified in the motion, the motion states, the phrase creature comforts was not used by any witness at trial, but it is used on Dr. Kirkpatrick's RSD Foundation website related to ketamine treatment. This statement is demonstrably and categorically false. In other words, you are a goddamn liar. You lied in your affidavit. You either lied or you didn't fact check. Either way, either one, you suck, is basically what that's saying. This statement is demonstrably and categorically false. In Ms. Rachel DeYoung's testimony on September 28th, 2023, she testified regarding so-called creature comforts. Mr. Anderson. And by the time she left you and give the jury just an estimate of when you were hoping she could get out of the wheelchair, before the hospital or after? After. The goal was before school. So I think in August, the school started. I'm not sure. September, that time? September. But she was not able to do that. No, we were really close. And then the pain was too unbearable. And I said, maybe by Christmas. And she's like, no, I don't like that answer. So she went home and she said, it's hard. She said, that's it. And she put on her backpack, got out her crutches, and made herself walk in the hall. And I believe maybe she didn't want to put herself in such a vulnerable, such a high pain position. Maybe in public, in the clinic, at agility, maybe she didn't know how it was going to make her body, her emotions respond, and that's why she didn't want to do it in therapy. She wasn't sure. But at home, she has her creature comforts. Her dad, her brother, maybe her favorite show. She can call a friend if it's not, she's having a really bad time with it after her experience to try to walk, but she did very well. Juror number one's use of the phrase creature comforts came 11 days later on October 9th when the trial, which was trial day 11. Look, as evidence that we have the evidence here in front of us, but as evidence that we knew about this, and by we, I mean the collective hive mind. When Megan Fox and I were reading this together, we said, they'd never used this phrase. It was a literal matter of minutes, like a very, very few number of them. Like 2 or 3 is my recollection. It could have been longer, it could have been shorter, but I remember just a couple of minutes. People in chat were like, no, this is where they said, DeYoung, she said this on this day. We said, well, really? What day was that? And just like that, someone's like September 28th or September 22nd, whatever the date was. So again, we all knew it was bullshit the instant that we read it. And again, we wasn't me, wasn't necessarily Megan. It was the hive mind, we. Juror number 1's use of the phrase creature comfort came 11 days later on October 9, 2023, which was day 11. Juror number 1 asked, Maya, during your stay at Johns Hopkins All Children's Hospital, you were at some time not able to view TV. Only a ticking wall clock was available to you. While you were at Johns Hopkins All Children's Hospital, did staff inquire if they could assist you in any way, such as adjust the TV, the volume, bring an item closer, further adjust your bed, not counting the 48-hour EKG? When it comes to creature comforts, were you made to feel comfortable, or were you made to, or just felt you were in a hostile place? And here's another important part of this. Defendant's counsel did not object to the question or raise the allegation of outside internet research in his pre-verdict motion to disqualify juror number 1, although the defendant had nearly a month to do so. Use it or lose it. It's what we talked about at the beginning. You have to do these things in a timely manner. If you wait just to see if it turns out against you and then you want to backtrack and go back and raise something you could have raised earlier, you don't get to do that. Defendant's attempt to disparage juror number 1's integrity is not only untimely, it overlooks the testimony of Ms. DeYoung in favor of the unsupported theory that juror number 1 combined Dr. Kirkpatrick's RSD Foundation website, combed Dr. Kirkpatrick's RSD Foundation website to uncover the concept of creature comfort. Yeah, that's a common word. And it was so cute though when they asked her about the creature comforts and she thought they were talking about her stuffed animals. That was so sweet and innocent of her. But adults, we've all heard, we all know what the phrase creature comforts means. I use it fairly regularly. Anyway, it's a common expression. And it was the name of a successful film, a television series, and an advertising campaign. See Merriam-Webster, Wikipedia, and Urban Dictionary. Oh, careful there, plaintiffs. Don't go directing people to Urban Dictionary if you can help it at all costs. That's a minefield. Urban Dictionary is a definite minefield. Do you remember the 21st night of September? Creature comforts is air conditioning. Yes. For me, it's my books, my tobacco pipes, and other things like that. Creature comforts is not to be confused for a luxury. JKD Buck, I still can't believe that juror number 1 and his wife are married. Well, before we get on to Urban Dictionary is better than Wikipedia. It was more entertaining than Wikipedia. We'll give it that. Let's go through these super chats that we have lined up here. Again, super thanks, Foghorn, for everybody involved rather than individual bells. Thank you for the support. Test. Brandon Lesko returns. Test. Your test has succeeded, Brandon Lesko. Welcome for the return. And Twisted Logic, gifted 5 Legal Vices memberships. If you got one of those 5 gifted Legal Vices memberships, please give Twisted Logic a super, super special thanks. Kyle Cowden, thank you. Like Elaine, JHACH has pooped in her mess kit. Okay, I was going to go down the poop story route that Mr. Anderson shared with Megan the other day, but we're not going to go there. If you want to hear that story, go back and watch Megan's last stream with Mr. Anderson. It was pretty funny. Smopo Vienna, thank you. Has been a member for 7 months. People hit the like at Jeff. Mug gets fired end of this week. Probably sending next week to UK. Oh, sweet. Will probably be a bit early gift. Hail Vice Squad. Oh, wow. Thank you so much. Dang. Thank you so much for supporting me for 7 months. Marilyn Chapin, thank you for your super chat. The defense has harmed juror number 1 and wife. Both have expressed a desire to speak, yet remain silent in order to mitigate future harassment, in my opinion. Well, I think I saw juror number 1 here as well. Juror number 1 and his wife are both here. So, well, yeah, there we go. A super sticker right there from juror number 1 himself. Thank you so much for being here. Thank you so much for the support. Always a pleasure to see you in chat. Thank you. And we've seen Mrs. Juror number 1. We've got Rob here. We haven't seen we don't think we have a Jewel sighting. Other than that, the rogues gallery of characters is here. Again, thank you everybody for all the support that you give. Now, let's crack the knuckles and get on to juror number 1's post-verdict comments. And the refrain you got to go with here is the one that we went with at the beginning. Everything that juror number 1 says after the verdict, post-verdict, should be met with a healthy "so what" at the end. Juror number 1 said this after the verdict. So what? And or any other derisive "so what" related comment you want to make. Juror number 1's post-verdict comments are immaterial to any consideration of alleged misconduct. There we go. That's a full-on punch there. Again, I love the way this motion is worded. The first sentence is the only thing this section really needs. Everything else is icing. Everything else is a little flavor. Everything else is a little salt. There's a little garlic sprinkled in there just to give it the flavor and to fill it out. A little bit of baking powder to get it a little rise in it. So juror number 1's post-verdict comments are immaterial to any consideration of alleged misconduct. The court expressly told the jury that they were free to talk or not talk, to reveal their thoughts on the trial and their experience on the jury or not, based solely on each juror's discretion. I don't need to say anything else. This is the problem with a well-written motion. It doesn't leave me much room to talk because I don't have to, because it says exactly what I want to say, and it's not like the other motions where they would say things and then you'd have to break it down and dissect it and explain what the hell they're talking about. This is just short, concise, and to the point. Okay, the instruction to not talk about this case will be, this is what the jurors were told by the judge. The instruction to not talk about this case will be over. So you will be free to talk about the case or not talk about this case. It's going to be up to each of you whether you wish to preserve your privacy, unless he forgot. The judge left out the part where he says, unless the defendant thinks they can dig up something on you and then they drop your government names and your address in a motion and release that out into the wild. He forgot to add that parenthetical part. Yeah, so you'll be free to talk about the case or not talk about the case. It's going to be up to each of you whether you wish to preserve your privacy, unless the defendant decides you don't deserve your privacy, and then they go out and they start slinging this stuff out into public. The lawyers and their agents will not be able to approach you. They'll just throw out your information in a motion, dumbasses. You, of course, may approach the attorneys, but again, that's going to be up to each of you. At this point in time, I'm going to give you the official discharge instruction. When that occurs, I'm going to have the court deputies escort you out of the building and take you to your cars. So thank you very much for being with us. Members of the jury, on behalf of the parties, the attorneys, and the people of the state of Florida, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affairs as long as they wish. Therefore, the law gives you a unique privilege not to speak about the jury's work. The lawyers and their representatives are not permitted to initiate any communication with you about the trial. However, you may speak to the lawyers or anyone else about the trial. You also have the right to refuse to speak with anyone. A request may come from those who are simply curious, or from those who might seek to find fault with you. It will be up to you to decide whether to preserve your privacy as a juror, unless your information is thrown out there by the defendants in a motion. At this point, this is the last time I'm going to say this to you. You do not have to talk about this case. You may talk about this case or not talk about this case. You may watch or not watch any news accounts. You may approach or not approach anyone. So at this point in time, I am discharging you with the court's thanks and the people of the state of Florida for your time and attention. If you could follow the court's deputies, Florida Standard Jury Instructions 801.4. Juror number 1 abided by his duty as a juror during the trial, and the court already assessed juror number 1's alleged bias and prejudice against defendant. Oh, see, look at the way that's worded. This is literally, he didn't need anything other than this. Juror number 1's post-verdict comments are immaterial to any consideration of alleged misconduct. Why? Because the judge said so. Let's move on to the next argument. You don't need to baffle them with bullshit when you've got the facts on your side. You don't need to do this. Why? The judge said so. The end. Brilliant. Juror number 1's potential disqualification addressed on November 6th, 2023. Oh my gosh. See, this is the sad thing. You shouldn't have to talk about each one of these, but the defense raised all of these issues, and you need to address the issues that are raised so you don't create the presumption that you agree with them by not disagreeing with them. Juror number 1's potential disqualification addressed on November 6th, 2023. On November 6th, 2023, this court heard defendant's motion to disqualify juror number 1. The court denied defendant's motion after a lengthy discussion on whether juror number 1 had displayed any sense of bias or prejudgment. Any sense of bias or prejudgment. Any sense. The court unequivocally, clearly, straightforward, powerfully, conclusively, unequivocally stated, I have not seen anything in my mind. See, this is where I'd be putting italics and bolds. I have not seen anything in my mind that would remotely come to me to get to the conclusion that he has prejudged anything in this case. On the contrary, okay, this whole thing would be bolded and underlined then, I guess. On the contrary, I am warmed by the fact that he has in his mind gone through, or what I believe to be his mind based on the questions that he's asked, my observation. I mean, the guy sits 5 yards from me. I've been watching him for more than 2 months. I mean, he's the closest juror to my physical vantage point and location. And I've been watching the guy, and I have not only do I not have a doubt, I don't have a reasonable doubt, but I have no doubt that this guy has not come up with any final or fixed opinion. Boom. That is just about as straightforward, conclusive, and concrete a statement as you will ever get. The court's observations are undergirded by one of juror number 1's questions towards the tail end of the defense case in chief. Juror number 1 asked nurse Sylvia Ballwegner the following. Your positive vibes are like a breath of fresh air. Did Maya ever mention any staff that she was not too keen on? The court reiterated later that it had no concerns about bias of juror number 1. There you go. Juror number 1's juror questionnaire. Defendant alleges that juror number 1's questionnaire was incomplete. I was once undergirded. I didn't like it. Nice one. All right. They say his questionnaire was incomplete, inaccurate, or otherwise deceitful. The single paragraph in the motion making this assertion, however, fails to proffer any verifiable facts. I got the dog snoring up a storm over there. Steph the Altar Nerd. What's up, Steph? It has been a minute, my girl. It is so good to see you here. Love to have you pop in. So yeah, this juror number 1's questionnaire, he's like, this isn't even, there's not even enough here to talk about. Well, let's do these two super chats here first. We can do the bells for each of them. Here for the truth with a $4.99 super chat. Thank you so much. Creature Comfort is my handheld fan at the moment. Life of a middle-aged woman. As a middle-aged dude, I hear you. Jason Smith with a $5 super chat. Thank you so much for whatever it's worth, and it's not much. The Judge Carroll meme guy is also. Oh, seriously? Oh, see, this is when I wish I had like a locals or something where you could bombard me with the memes. Because the memes that Megan Fox has on her locals are fire. They're absolute fire. Love every one of them. They're hilarious. And if you want to hear a good, clean, honest laugh, go back and watch Megan Fox's show with Greg Anderson. Dude has one of the cleanest, purest laughs ever. Right. Back to the Maya Kowalski case here with the defense's motion to have this thing dismissed because of juror number one misconduct and the plaintiff's response, which we're looking at now. They're trying to take that $260 million away from that little girl and her family. They're not doing a very good job because they're arguing and alleging these points of misconduct by juror number one that apparently they have zero evidence of. They're looking to bring him in for an interview to try to go on a fishing expedition to get more information out of him. Well, what are we talking about? Deborah Salisbury. Defendant's motion asserts that juror number one never disclosed on his juror questionnaire during voir dire that Deborah Salisbury Esquire was involved in juror number wife's 2007 domestic relations proceeding. So they complained that he didn't tell the court that this lawyer was also involved in his wife's 2007 case. Defendant, however, admits in footnote 11 that defense counsel does not know whether Attorney Salisbury represented juror number one's wife in that matter. So he didn't tell us that his wife was involved in these proceedings, and we're not even really sure that she represented his wife. Whatever. This is one of the more ridiculous arguments. They admit they don't even know whether Attorney Salisbury represented juror number one's wife in that matter, and defendant does not claim the referenced domestic relations proceedings involved juror number one. It didn't even involve him. Nevertheless, defendant claims that Ms. Salisbury was definitively involved in juror number one's wife's domestic relations proceedings. Going further, the defendant alleges misconduct because juror number one never disclosed this fact. What fact? How's that for an answer? I wish that was me just being expletive here. It's like juror number one never disclosed this fact. That is a sentence. That is a paragraph. It is equally in length with Jesus wept. 2 words. What fact? How's that? Sometimes that can be a very powerful legal argument right there. Juror number one never disclosed this fact. The entirety of the legal argument is what fact? The juror questionnaire asked whether juror number one knew Deborah Salisbury Esquire, not whether his wife knew her. Bingo. The court should take judicial notice of a fact that apparently escapes defense counsel. Because remember during these motions, especially during the 144-page motion that we went through on 2 phases, the refrain from the defense was the jury was just too damn stupid to figure this out. The jurors couldn't wrap their minds around this concept. This concept was so complex that the jurors just couldn't figure it out. Well, here, that's another backhanded slap to the defense counsel when they're saying the court should take judicial notice of a fact that apparently escapes defense counsel. Spouses can and do have different professional and social contacts and separate lives before they marry. The paragraph in the motion addressing the Deborah Salisbury fact also does not establish that juror number one's wife even knows Mrs. Salisbury. Defendant draws no connection between what appears on the Sarasota County Court docket and any relationship between Ms. Salisbury and juror number one, his wife, which must first be established. Defendant offers nothing to show that juror number one has ever heard of Ms. Salisbury. It's the bus stop people at it again. Just the 6 dumb bus stop people. Importantly, Mrs. Salisbury never testified in this case, even if defense counsel had been able to draw concrete connections between Ms. Salisbury and juror number 1's wife, and then from there somehow demonstrated that juror number 1 also knew Ms. Salisbury based on Ms. Salisbury's alleged encounter with his wife some 16 years ago. The court and the parties would be left with a quandary. What possible difference would any of this make in a case where Mrs. Salisbury did not testify and her name was excised from any written communications to avoid injecting Chapter 39 dependency court issues into this trial? As the court is well aware, the juror questionnaire provided in voir dire were thorough, specific, and drafted with the intent to weed out any potential conflict. Juror number 1's juror questionnaire indicates his honesty. He clearly indicated his law enforcement background and checked yes to criminal history for either himself or an immediate family member. Juror number 1's wife, alleged professional encounter with Ms. Salisbury is a red herring and wholly irrelevant to juror number 1's ability to assess this case as a juror. Got another one in there. That was a double punch. Oof. Wow, we're an hour and 26 minutes in. Let's take a quick little break here to cleanse the palate before we jump into the defense's critique of the Take Care of Maya documentary and the plaintiff's response to that particular critique. Ooh, we've got 974 concurrent viewers here and 524 likes. That's like half of you haven't done your job. Almost half of you haven't done your job. Get down there and hit that like button. You're watching this. We've enjoyed it for more than a couple of seconds. So clearly, you like it. So hit that like button. And if you haven't subscribed, I would be deeply honored if you would do me the honor of gracing me with your subscription. This is what we do. We cover things like this. We cover motions. We're doing the YNW Melly trial. We've got Friday's going to be a big Alec Murdaugh day because he was just sentenced to 27 years for the financial crimes. We're going to be watching that. We're going to be watching the victim impact statements and the sentencing and that on Friday. Tomorrow, we're going to be watching the closing arguments for the O.J. Simpson trial, a little bit of a retrospective. We do every Thursday, O.J. Simpson Thursday, but that's about to end in a week or two. And then we're going to go back to another old trial that we'll announce in a little while. Every Monday we do maritime cases because that's mainly what I do. We do lots of things here. I would be honored if you would subscribe to the channel, give me a chance, and hopefully we'll get to see a lot of you here. And while you're at it, take our like and subscribe poll. Today's like and subscribe poll, after you've hit the like button, after you made sure you're subscribed, pop on over here and take our little poll in chat. What is your opinion on the Maya Kowalski lawsuit judgment against JHACH? 4% of you say her claims are unfounded. And I do like dissenting opinions. I don't want this to be a complete echo chamber where everyone's like, yeah, go team. We're the choir. Let's preach to the choir. No, I like the dissent. I like well-reasoned, calm, rational, professional, adult discussions with disagreeing parties. So 4% of you say her claims are unfounded. 4% of you also say both parties are responsible. 43% of you say there's not enough zeros. And 49% of you say she deserves the compensation. So 82% of you say that she deserves it and or there's not enough zeros. She deserves it or she deserves more. That's the poll. If you're on an Android, the poll is blank. Yeah, the poll is blank if you're on an Android because for some reason YouTube and Android are not cooperating with the polls these days. Been there, done that. Adult discussions gets up to leave. All right, let's get on to the Taking Care of Maya documentary. Well, Duncan Idaho says, I don't know, man. I haven't seen any well-reasoned arguments for why the Kowalskis are actual liars. I have to agree with you, but, someone can. On Android, the poll worked for me. It doesn't work for me at all on my Android. It works on the computer, but it doesn't work on any of my Android devices. But, hey, it's out of my control. YouTube is some BS. All you can't vote. Just on the vote, if you... The two middle ones, the two middle choices are the claims are unfounded and are responsible. The first one is she deserves compensation. The bottom one is there's not enough zeros. Use that to guide your fingers on the white background. I love Melly reading the transcripts, lol. All the she is hilarious. Well, we're going to pick that up again next week, so follow that. All right, let's get back into this. Thank you so much again. Hit the like, hit the subscribe, take the poll. We'll address that here at the end. Taking Care of Maya documentary. Defendant makes an unsupported logical leap in alleging that despite juror number 1 denying in his juror questionnaire that he had seen the Take Care of Maya documentary on Netflix, and further denying having any conversations or overhearing any conversations concerning Take Care of Maya, that this seems unlikely. They're like, oh yeah, the defense was saying, well, it seems really unlikely that he didn't talk about this with his wife and he didn't watch it. That is it. This seems unlikely. That is the extent of the defense proffer to dispute juror number 1's answer to the Take Care of Maya questions on the jury questionnaire. There's no facts offered to create a credible dispute over juror number 1's answer. So saying, yeah, their big evidence that he was lying on the jury form when they asked him about this was, it seems unlikely. Again, the 144-page motion to renew the directed verdict, to give a new trial based on judicial errors, to give a new trial based on improper financial awards, and the motion to have the judge unilaterally reduce the amounts. Those are perfectly valid, reasonable, professional, and damn near required motions, the post-trial motions to be filed. I have no problem with those. None at all. None whatsoever. I have all the problems with this juror number 1 motion to declare a new trial based on juror number 1's alleged misconduct, because that's their offer of proof. That's the best they can do. That's whether you'd seen the Taking Care of Maya, or have you had any conversations or overheard conversations about the Netflix documentary? He answers no. And the best they can do to question him and want to pull him in for an interrogation section to see to find out whether there's other misconduct, whether there's any misconduct at all. Their basis for doing that is, it seems unlikely. I doubt it. That's what they're saying. That's their evidence that he's lying about not watching the documentary and lying about not hearing about it. I doubt it. That's not evidence. I'm sorry, saying I doubt it. That ain't evidence. That I have deep professional problems with this motion. I couldn't do it. I wouldn't do it. It's beneath a member of the bar. It's beneath the professionalism. It's damn near beneath the ethical requirements of a member of the bar to put out something like this, directed at a specific juror who did what they did for 9 weeks. It's icky, and it leaves a really, really bad taste in my professional mouth. That's it. This seems unlikely. That's the extent of the defense proffer to dispute juror number 1's answers to Take Care of Maya questions on the juror questionnaire. There's no facts offered to create a credible dispute over juror number 1's answers to those questions. The rest of the direct attack on juror number 1 is conjecture based on juror number 1's wife's so-called heavy engagement, investment, and close monitoring of the case, the court docket, and her following social media of the movie producers for the documentary. These are the exact words. These are the exact words that Megan and I used when we went through the motion. Hyperbolic, inflammatory, and imprecise allegations against juror number 1's wife were addressed further below. Those are the exact words that Megan and I used. Hyperbolic, inflammatory, and imprecise allegations. Defendant has not demonstrated that juror number 1 failed to disclose any facts on his juror questionnaire. Yeah, the juror, they said that he failed to disclose certain things. Sean, shame on you. I'm not even gonna pull that up, but yeah, I saw that. Juror number 1's wife alleged improper actions. And I gotta say, this feels so weird talking about these things and these people with them here in chat. Apologies for all the weirdness that I'm bringing to your life. It's It's weird. But yeah, I had that during the Zachariah Anderson case as well, during that murder trial when Zach's brother and sister were in my chats. It's awkward talking about people while they're here and pretending like they're not. So apologies for making this weird. Each and every time the following questions were asked by the court, countless times during the trial, juror number one and the rest of the jurors always answered in the affirmative. And again, this is an important thing to point out. They keep saying juror number one did this. They kept saying, calling him the leader. You know, the leader of he was the foreperson. He was the foreman of the jury. He was the leader. He was their leader under his direction, under his leadership. Juror number one did this. Juror number one did that. Hey, Rob, what's up? How is it that Jeff has somehow used less profanity covering this than I did? We're close. We're close, Rob. I used up my profanity allotment during the previous two motions. Yeah. They keep focusing on juror one. Juror one, because juror number one did this. Because he was the leader, because he was the foreperson, he was the ringleader. Under his direction, all this happened. What the defense is not acknowledging, and they're purposely obfuscating, I believe, is that there's 5 other effing people on the jury. There's 5 other people there. Legal advisor, you're having fun with the lol fuel. This is the Anderson motion. It's the response. It's the punch in the face response to the lol stuff. But yeah, they're purposely not pointing out that there's 5 other jurors on the panel. There's 5 other independent human beings that have reached the same goddamn conclusion that he reached. They're trying to make this a jury of one that they alleged with 0 facts. They just alleged that there was misconduct. So somehow alleged misconduct by one person completely vitiates everything and marginalizes and completely removes the other 5 thinking adult people from the equation. So I think it was very good for them to slip this in here, that each and every time the following questions were asked by the court, juror number one and the rest of the jurors. Let's not forget there's 5 other jurors on the jury panel. The rest of the jurors always answered in the affirmative. I want to confirm, while you were away, and again, this happened after every break, even if it's a 5-minute walk down the hall to piss, every break, going into court, coming out of court, I want to, whenever they came back, I want to confirm that while you were away, you did not discuss this case amongst yourselves. You did no investigation and you received no information. Is that correct? Members of the jury, I want to confirm while you were away, you did not discuss this case amongst yourselves. You did no investigation and you received no information. Is that correct? No one approached you about this case. Is that correct? You have not seen any media accounts about this case. Is that correct? Every single one of the 6 jurors answered those questions in the affirmative, that they had not done any of those things. Nonetheless, and without any evidence that juror number one's affirmative answers to those questions were untrue, defendant launches into unsupported theories about juror number one's wife's influence over juror number one's view of the evidence in the case during trial. Plaintiff observed that defendant's position, the one spouse's knowledge or action should be attributable to the other, means the defendant's arguments are unpreserved as discussed above. The extensive online involvement of lead defense counsel's wife, discussed below, leads to the conclusion, apparently Shapiro's wife was all over Reddit. Leads to the conclusion that the defense knew all of this conduct before the jury retired. The failure to timely raise it was a waiver. Use it or lose it when you know it. You can't wait to see how it turns out and then raise the issue to hope to go back in time and turn back the clock. You should have pulled that reverse card before the other person threw all their cards on the Uno table, Jack. Juror number one's wife's social media and internet involvement. Juror number one's wife comment regarding juror number one's expected questions to Detective Graham. Oh my Lord. Yeah, this was another one that set me off during the as Kurt called it, the lull motions. Defendant alleges that juror number one's wife's social media involvement indicates that she had conversations with juror number one about this case. Defendant points specifically to juror number one's wife's comment on a YouTube stream. The juror Leo, law enforcement officer, will be asking questions. No effing shit, man. That's what a cop does. A cop asks questions. We were all, when it was happening, we're like, oh, he's gonna have questions. Of course he's gonna have questions. He's gonna have some questions that are probably very, very pointed that others wouldn't ask because they wouldn't have the framework to ask. Excuse me, I'm gonna have to cough here in a second. Sorry about that. Yeah, we all said he's going to ask questions, and it's only natural. Duh. Right. Let's get on with it. The juror Leah will be asking questions. Duh. Essentially, defendant contends that the only explanation for juror number one's wife's comments is impropriety. However, and this court has pointed out, given juror number one's background as a law enforcement officer, we could have expected that he was going to ask tough questions, sharp cross-examination type questions. It's even in the court transcript. This court also pointed out that 9 weeks into this trial, I can tell you without any sort of certainty that juror number one has been testing the evidence in this case, every single witness. Well, I don't think he's asked a question today, but I think he asked a question on almost every single question that wasn't by deposition. There's a whole bunch of footnote stuff we don't need to read. The court went further to say, and I go back to this, is a person with a law enforcement background. And he's, in my mind, taking what is sharply conflicting evidence that both sides have skillfully and artfully put forward to this jury, and he's trying to make sense of it. We all said the same thing. It would have been absurd in a case where the jury is allowed to ask questions for the cop not to ask sharp, pointed questions. After 1 week of trial testimony and hearing the jurors' questions to witnesses, it became evident that juror number one was going to ask a lot of questions. He consistently asked questions throughout both plaintiffs' and defense's cases in chief. The notion that juror number one's wife had improper communications with juror number one ahead of him asking questions to Detective Graham is meritless speculation. The court knew that he would ask questions. Plaintiff expected it. Perhaps defendant's counsel was surprised by his questions, or more likely, failed to appreciate that Detective Graham's abrasive nature and aggressive interrogation of Maya Kowalski would backfire. Every single witness that, virtually, I didn't see every single witness the defense put on, but every single witness that the defense put on that I saw were generally scowl-faced, unlikable people. You shouldn't be surprised when people react negatively to them. 2, juror number one's wife's comments regarding the jury deliberation notes. Defendant's motion alleges that juror number one's wife's comment about the jury deliberations note was a result of inside information, and she could have only obtained from her husband, juror number one. The comment reads, "I think the note yesterday was frustrated jury that cannot reach dollar agreement, and it will take days." Yeah, we'll talk about that in a second. Plaintiff's counsel had the same observation. It was evident that the jury was frustrated, as indicated. Oh, let's see, is this the one? Nope, this isn't the one that I thought it would be. We all thought, every single one of us that was watching, at least, can't remember if I was watching it. I watched this part both on Megan and Rob's streams, and generally it was right across the board. An hour into deliberations, the jury comes back with the notes. We want to see the money bags. We want to see the stuff related to money. Every single person knew, all right, they've reached a verdict. Now they just want to know how many zeros to add. We all had that across the board, and I didn't talk to juror number one about it. I didn't talk to juror number one's wife about it. I didn't see any impropriety, but I just knew that when at the end of this trial, when the jury walks back and they come back an hour later and go, we need some stuff about money, they're done. We all knew that. We all know they're frustrated. And then perhaps Well, plaintiff's counsel had the same observation. It was evident the jury was frustrated, as indicated by the second note, which read, "Y'all, we have not been able to locate any of the calculations about future amounts. Witness Kirby was on Zoom, and Whitney mentioned them today, and it was said that we'd have all this at deliberation. Well, if we do not have it, and if we ain't found it in all these files, so without these witness figures, you'll be lucky if there's enough awarded to pay your gas to drive to court, or we'll be here until next Friday." The one I liked was the one that did the shit thing. He was like, we need to find out where this shit is, or whatever that said. Uncivil Law says, "Legal advice, are you sure you're not the wife of juror number one? You're sounding sus to me. I have proof that I'm not, because she's here in chat, and I'm not nearly as what's the word I'm looking for? Dexterous and able and agile-minded enough to be talking in one voice about one thing and typing on another account. I clearly lack that ability. That is a demonstrable, objective fact that I'm not smart enough, agile enough, or able to pull off such a stunt. So, yeah. Well, if we do not have it, we ain't found it in all these files. So without these witness figures, you'll be lucky to get awarded enough to pay your gas, or we'll be here till next Friday. More importantly, juror number one's wife's sentiment that the jury was frustrated matched the overwhelming sentiment of the social media commentators and public followers of the trial. Thousands of comments were posted to this effect. Exactly. Seems the jurors want to be done and they can't agree because of missing info. Lol, they mad as fuck. I like Megan Ann here. They mad as fuck. The jury, I think the jury know the verdict by now, but they have to put the numbers together. Jury wants to go home. How are the instructions going to keep them another day? I think they'll be seriously annoyed. They clearly do have a verdict. See, this is what we were all saying. It's not some magical thing that only could have been learned by passing information between juror number one and juror number one's wife. That's just ludicrous. Juror number one's wife needed no inside information to interpret this note. None of us did. We had no inside information, and we knew goddamn well how to interpret that note. They just need all the information so they know how many zeros to tack onto the end. The jury told the court that they were frustrated over the numerical values that they could not find. Juror number one's wife's comment regarding the jury not liking Catherine Beatty. Well, we can just end that right there, because I haven't seen a single rational human being who liked Catherine Beatty. Nobody liked her. She was like the most unlikable person in the entire trial. Maybe Susan Smith. It's a toss-up. It's a coin toss. Which one was more evil than the other? Defendant also alleges that juror number one's wife had inside information from her husband based on her YouTube comment saying they, the jury, did not like Kathy Beatty or any of the witnesses defendant presented at trial the day prior. He says it right here in the next paragraph. Defendant ignores the most rational explanation for the comment. Juror number one's wife was present in the courtroom on the day that Ms. Beatty testified and could see and assess the jury members' reactions to Ms. Beatty's non-credible testimony, as well as the other witness testimony that day. Exactly. The most logical explanation is she was in trial that day and she saw that nobody liked them, that everybody hated their asses. Oh my Lord. I'm glad this is getting more into the law side of things, because it just made me angry the first 20 pages or so. Now we're getting to the really ridiculous parts of the response to the ridiculous parts of the defense's motion. It wasn't Susan Smith. It was Sally Smith. I think it was Smith. Was it Sally Smith? It was Sally Smith. I don't know. I get my evil Smiths mixed up. Susan Smith, both child killers. Yeah, I can't remember. Anyway, Smith. Right. Juror number one's wife's other social media presence. Yeah, Susan Smith, Sally Smith, same difference. Yeah, they're both Karen Smiths. Defendant highlights multiple other social media comments made by juror number one's wife and focuses on her activity during, quote, live stream coverage of the trial on Law and Lumber. Congratulations, Rob. You made it in this motion too. Recovery Addict and Lawyer You Know YouTube channels, motion page 8. Defendant states on a near daily basis, juror number one's wife spent hours online engaged in commentary about the trial proceedings, both in real time and after the trial day had ended and the jury was sent home, including her husband, juror number one, with whom she resided. Again, that insinuation that they lived together. And a juror living together with his wife. Shh. The online presence of juror number one's wife undermines defendant's main premise that she must have discussed the trial with her husband because she was active online. She had ample opportunity to learn that way. Right? She had ample opportunity to learn that way about what was going on in the trial. Despite the large amount of time juror number one's wife apparently devoted to online commentary during the trial, defendant cannot produce a single post indicating a discussion with her husband regarding the case at any point during the trial. In each instance, and for each and every social media post by juror number one's wife, defense counsel ignores the common sense explanation. As an example, to explain juror number one's wife's comments reflecting concerns over plaintiff's remaining time, cognizance of the 55-hour limit, defendant asked the rhetorical question, but why was juror number one's wife of the opinion that plaintiffs were running out of time if she wasn't discussing the case with her husband? Well, the rhetorical question is easily answered. Anyone with even a casual interest in the trial heard the court repeatedly caution plaintiff's counsel about their remaining time. We all said the same thing. We all knew they were running out of time. Megan was having a panic attack. Everybody's having a panic attack because, you know, we got it. We don't waste time. Don't waste time. Keep moving on. We all knew the shot clock was ticking. The remaining time on the shot clock was announced at the end of each trial day. Defendant suggesting that juror number one had a unique perspective on the shot clock, which he must have shared with his wife, is absurd. Absurd is a good word. In fact, the jury probably had the worst perspective on the issue since the shot clock announcements were made outside of the jury's presence. Oh, that's a good point. The jury wasn't there when they announced the time they had left. It's a chess clock. It's not a shot clock. It's a chess clock. Boom, boom. You got to hit it with your moves. Finally, juror number one's wife posted comment, "I think you are right," was in response to another post from an observer known as T-Bex as follows. Ma'am, being so combative makes it look like you care more about a narrative than about giving honest testimony. Anderson should just sit down. The jury will ask the good questions for him. Oh, come on. Anderson was asking good questions, T-Bex. This lady is acting like her job is at stake. Makes me wonder what management has said to her. Dun, dun, dun. Right? Well, Mrs. O, the defense wasn't talking about their own lawyer's wife because that would make them look hypocritical now, wouldn't it? So they didn't do it. So now the prosecution is doing it for them. Juror number one's wife monitoring the court stuff. By the raise of hands, one in the chat, if you ever looked at the court docket, if you were ever monitoring the court docket during this, were you on the Sarasota, Florida County Clerk's docket site? I'll put a 1 in chat if you were there. I'll put my 1 in there too. Yeah, see? There's some 1s here. All of you clearly had improper contacts with juror number 1, it looks like. Yeah, 3. Now I need to go back here and see if juror number 1's wife actually put 1 in the chat. Anyway, so a lot of us did that. I started doing it after the trial was over because the trial apparently wasn't over after the trial was over. Defendant next argues that juror number 1's wife's post reflects that she was even monitoring the court docket and reviewing court filings, just like we're doing now. Sweet baby dumpster Jesus. We're doing that very thing right now. This ignores the many of the YouTube channels and personalities mentioned in the previous page. I wasn't doing it, so I wasn't mentioned. I kept my nose clean. But everybody else kept their nose clean too. They just made it look like they weren't. The evil defense was insinuating it wasn't. So yeah, in other words, I'm just bitter because I'm not big enough to be mentioned. Sadness ensues. So everybody was doing it. YouTube channels and personalities mentioned on the previous page of defendant's motion and above regularly notified their audiences of recent filings by the parties and even read and analyzed the motions live on YouTube with thousands of trial watchers tuning in. Hey, we've got hundreds. We have 1,000 plus. We've got 1,035 here, 1,035 people. And I've noticed we've only got like 650 likes. Come on, guys, hit that like 500 more times. This better be to 1,000 likes by the time I'm done, or I'll beg some more. All right. So that's what they're saying. Is like, okay, that's not a big deal because literally everybody on YouTube is doing it, and everybody in the YouTube people's chat is doing it. What's the problem? Juror number one's wife most likely obtained her knowledge of and comments on recent filings from these YouTube channels. But even if she were accessing the court's docket directly, she had every right to do so as a member of the public. Take that, defense. Juror number one's wife's presence in the courtroom. Oh, that's right. I liked how they said that in their original motion. They said, and she was physically present. She physically appeared in court, like she's like this apparition that just forms in a corner. She physically manifested there in the courtroom. There was a physical manifestation of juror number one's wife in the courtroom. We saw it. It just appeared right over there next to where Jesus would have been if he hadn't been thrown in the dumpster. I saw it right there on the wall. Shadows. And sorry for that little idiocy. At no point was the jury instructed that their spouses were prohibited from observing the trial, either online or in person. Well, duh. All members of the public are welcome to attend, whether they had relationships with jurors, witnesses, lawyers, or parties. In fact, Mr. Shapiro's wife and children attended the trial on many days. Family members of Dr. Jenny Dolan and Dr. Tepa Sanchez also attended the trial. A juror's wife attending one day of trial does not violate any law or rule or oath, and certainly does not indicate juror misconduct. So, off you fuck. Just take that argument and off you fuck. Jules, a member of the viewing public's supposedly improper actions. Defendants focus on Jules, a member of the public who relayed her observations via social media and through various YouTube legal commentators throughout the trial, has no bearing on juror number one's conduct or plaintiff's counsel's actions in the courtroom. Okay, this is the one that pissed me off. They did it for Jules, and I think they did it to a certain extent for juror number one's wife. This argument that they were somehow an agent of the no, and they don't even get into it here. The allegation that Jules was a de facto agent of plaintiff or plaintiff's counsel is preposterous. Jules played no role in the plaintiff's trial strategy or decision making, and her opinions were hers and hers alone. So off you fuck. Jack Cole, see that was the one that really made me angry. I was really pissed off at that. To say that agency means things. There's a lot of requirements that need to be met in order to be considered someone's agent. An agent, in fact, is a thing. That actually has legal meaning. And I mean, it annoyed the shit out of me. That argument did. Number two, Jack Kowalski allegedly smiling and nodding at Jules after Judge Carroll denied defendant's disqualification motion. So what? The video the defendant cites showing Mr. Kowalski raising his eyebrows and turning to the gallery, there is no footage or any indication that Mr. Kowalski is looking at Jules. In fact, Jules' head is down when the camera pans to her. One of the plaintiff's expert witnesses, Dr. Scott Richards, was seated next to Jules, and Mr. Kowalski was looking at him as the two discussed the trial throughout. Well, I'm glad to help you, Nikki McCormick. See, again, this is it's so frustrating and so angering. They were looking and nodding and sending signals back and forth when she wasn't, and they weren't. Internet social media activity. Despite the absence of any demonstrated connection of this pre-verdict social media activity to juror number one, the motion complains that specifically the, quote, entire internet community was made aware of the heavy bias in plaintiff's favor on the part of a juror's wife. I'm part of the internet community, and I wasn't made aware of any heavy bias in plaintiff's favor on the part of a juror's wife, plainly compromising the integrity of the jury process. Yeah, I don't think, no, I don't think so. That's not how it works. Quick Bites has got to leave. Bye, Quick Bites. Good to have you here. Thanks. Right. The entire community, well, minus you and me, KT. Just minus you and me. It was everybody else. Leaving aside the question of how the defense was able to discern this information, see, this is the problem with using this superlative hyperbolic language. Everybody, the entire internet community did this. Then you can go back and okay, was there one person in the entire internet community that didn't do this? Well, then it wasn't the entire internet community, and therefore you're exaggerating. You're using these superlatives. You're using these hyperbolic phrases. You're doing all of these things, and as I said, this undermines your case. I kept saying this, the use of this ridiculously overwrought language undermines your arguments. It's stuff you have to do when you don't have the facts on your side. You have to try to conflate it. You have to try to exaggerate it and make this big production of it and bring in the drama. But then, so you think you're being cool by saying the entire internet community is aware of it. And then they come in and go, I bet there was a few that weren't. You're wrong. And that sort of your whole little argument collapses like a little pile of wet cards. So leaving aside the question of how the defense was able to discern this information, what the entire internet community was aware of or does not constitute misconduct by juror number one. Moreover, a defendant is hardly in a position to complain about internet and social media activity during trial by third-party observers, as demonstrated by the defendant's own robust internet activity during trial. As shown in the screenshots attached here to as Exhibit D, defense counsel Shapiro and other members of the defense team were receiving substantial ongoing feedback and support from the internet community throughout the trial. In a November 11th, 2023 message, attorney Shapiro communicated that, hey, we saw this on Reddit. I became aware of the Reddit group, the Maya Kowalski free or whatever it is, I think Friday. And this was one of the first things I saw. Hey, I want to thank you and everyone else who is sleuthing this so carefully. Or do we have to do the Megan ASMR voice? Hey, I want to thank you and everyone else who is sleuthing this so carefully and meticulously. I've gone through the Reddit threads on juror number one with almost 1,000 comments. Everyone on the defense team is monitoring this closely. If anyone in the community has comments to make, you can feel free to keep posting there because we're going to read all of it and put it towards emotion. Sick. I agree that the idea the wife knew when a verdict was coming and that they were arguing about is shocking, and I hope the judge will feel the same way. Oh, I need to be higher and gayer. I'm sorry. gayer. Okay, sorry. It's my way too masculine. People are saying, okay, I'm sorry. I'll gay it up next time. Jeez. Damn it, Megan. All right. I'll remember that if they quote from him again. Also omitted from the motion is any mention of the active involvement of attorney Shapiro's wife, Kisa, on a social media chat group during trial. As shown in the appendix below, Kisa Shapiro, undoubtedly an agent for defendant. Ooh, that gets a knockout punch there. Kisa Shapiro, undoubtedly an agent for defendant. I love these parenthetical statements. Participated in a chat group by advocating defendant's trial position, just as Jules, whom defendant erroneously claims was an agent for plaintiff, advocated positions favorable to plaintiff. Given defendant's position that the wife's knowledge should be imputed to the husband, Mr. Shapiro is deemed aware of all Kisa Shapiro's postings during the trial and, by not objecting before the verdict, has failed to preserve this entire issue. One more just for good measure. Just rabbit punch him while he's down. None of this internet activity is relevant to the relief sought in the motion without some objective act committed by or in the presence of the jury or a juror. Again, all this shit we've just talked about, nothing is connected to juror number one or anything that juror number one saw, heard, or experienced. Okay, let's take a little break here and catch up on the super chats before we get too far out of the way. Oh, thank you, Delasander. You're so nice. You make me feel good. Or your defense was unshickingly abysmal. Unshickingly. I don't know, that's a good turn of phrase. Lars Mickler, many thanks for your work. Well, many thanks for your super chat. Thank you so much for the euros. Oh, we need to do the big foghorn, the group thanks for all of the super chats that have come in. Thank you. Thank you for your support. You are now officially part of the Vicerax crew, everybody that's watching this here right now. And Duncan, Idaho, when the defense motion says it strains credibility, what it sounds like to me is, search your feelings, Judge. You know it to be true. Come on, Judge, says Duncan, Idaho again. They're married, for Pete's sake. Of course they were talking about the case against instructions. Right, exactly. Come on, Judge. The DCV Titan. Could be weirder. You could invite them on. Yeah, well, yeah, it could be weirder, but it's not going to be weirder. Rainman YYC, is that like YNW Melly? Rainman YYC, Judge, show cause hearing scheduled. Bring both your checkbook and toothbrush. I like that. That's a good one. And KT has been a member for 11 months. Jeff, your anger is palpable. Well, you can palp me anytime. Thank you so much. And Lawn Lumber, you let Leo on the jury. You basically asked for this. Of course, he was a four-person, but also people are independent thinkers. Well, apparently not, because they were all under his direction. He was the leader, etc., etc. Heather Sparrow, I was on a jury, and there was no way one person was going to push all of us to their will, right? That's kind of not how it works. That's why we have hung juries. Daily Quick Bites, legal advices flash. This just in. The JHACH defense has uncovered photos of Juror number one on the grassy knoll of Dealey Plaza dated November 22nd, 1963, and he appears to be holding a rifle. And he lived with his wife. Lorraine W., I wish for Maya and family to get treating therapist order not to let defense subpoena records any further so they can try to heal without interruption and interference. I just wish the defense would take a loss, save whatever face they can, and, off. And Duncan Idaho to catch us up with the final super chat. Duncan Idaho, the $10 super chat. I think the defendants had thought juror number one would work to their favor as a retired Leo because all the defense witnesses had been acting not like doctors, but police investigators against the Kowalskis. I think you're right. I think that's a good point. They had the chance to get him off one way or the other for cause, for with the preemptive strike. They could have very easily got juror number one. The fact that juror number one sits on the jury is due at least half because they wanted him there. The defense wanted him on that jury. Okay, let's keep it going. Keep it going here. Oh, hey, Jules has showed up. We have the whole gang here. As a U.S. citizen, open court to the public, I'm allowed to attend and comment and come to my own opinion and share it. And I'm allowed to talk and take pics outside of the court because I live in a free country. Yep. There you go. The relief requested in the motion cannot be based on post-verdict statements by juror number one. Again, there's the word, post-verdict. Oh, I see it's highlighted in the next sentence as well. The motion relies on statements by juror number one after the verdict. Remember that thing we read by the judge up there saying, thanks you all, that's all folks, go away now? Everything that happens after that is after they've been discharged as jurors, and they're not under their jurors' oaths anymore. On discharging the jury, the court instructed the jurors that they were at liberty to comment publicly about the case, which is correct. See Florida Standard Jury Instruction 801.4, instructions upon discharging the jury. The lawyers and their representatives are not permitted to initiate any communication with you about the trial. However, you may speak to the lawyers or anyone else about the trial. It is certainly true that following the verdict, juror number one made known his decision to support the verdict for the plaintiff. There is nothing improper in that in our civil justice system. Yeah. Sniper's Nest, you and Megan ripping these jerk faces is amazing, Jeff. Thanks. Well, there's other people that are also ripping these jerk faces. We're just two of the jerk face rippers. Here for the truth. Megan, thanks for the heads up about Jeff streaming. Oh, thank you, Megan, for giving the heads up. Been a long time. Oh, hey, you two are hooking up again. Hey, I mean, meeting up again here. That was a bad choice of words, wasn't it? Sorry about that. All right, it's certainly true that after the verdict, juror number 1 made known his decision to support the verdict for the plaintiff. There is nothing improper in that in our civil justice system. Indeed, all the jurors made their individual decisions public when they were polled after the verdict was read. And that's another thing showing that they were not unduly influenced by juror number 1, regardless of what the people would like, what the people on the defense team would like you to believe. That's one of the reasons why you would want to poll a jury, to avoid any problems like this, because each and every juror is asked whether that verdict was their own independent conclusion. Yes, they all said, right across the board. Flux says we need more gay Shapiro. And Paige says Rob ripped him hugely last night. Definitely recommend watching a stream from the last night. Just make sure you do that after we're done. Moreover, juror number 1's ultimate decision to support a verdict in favor of the plaintiff cannot be considered as evidence that he made the decision through misconduct. The evidence properly admitted in this trial provided an ample basis for the jury to decide against the defendant. For example, near the end of the trial, the jury heard evidence from which it could very reasonably conclude that the defendant had deliberately attempted to mislead it and the court about the defendant's accreditation status. Yes. If defendant is searching for a reason for juror number 1's decision to support plaintiff in the verdict, it need look no further than its conduct and the conduct of its counsel during the trial. I was listening to Greg Anderson talk to Megan yesterday when they were going over this motion. He said there was a record number of cell phone deaths and thefts during this trial, to paraphrase him. Apparently everybody's cell phone was broken and couldn't be the conduct of defense counsel was not good, and it continues in the fact that they wrote this motion to have a new trial because of juror number 1's alleged misconduct. So I really, really, really love the way that the plaintiffs are taking it to them in this motion. As I said, this is one of the best written motions that I've seen in a long time. The discovery requested in the motion, including a deposition of juror number 1, should be denied. Abso-fucking-lutely it should be denied. Absolutely should be denied. For everything we've talked about in the last 30 pages. In addition to the defendant's failure to provide sufficient prima facie evidence of misconduct by juror number 1, there's a further compelling reason for the court to deny subjecting juror number 1 or his wife to discovery from defendant. The motion repeatedly invokes protection of the integrity. Oh God, my blood pressure just spiked again. Every time it goes, I can just feel this flush go through me. The motion repeatedly invokes the protection of the integrity of the judicial process or system to justify the relief it seeks. The cynicism of such statements is remarkable in light of the defense counsel's conduct at the end of the trial and after the verdict. To anyone watching the last day of trial, the disrespect toward the court's rulings and later at the verdict was palpable. Oh, Anderson, I love you. We actually, while we were going through the original motion for a new trial due to the misconduct, Megan made the bad decision of saying she would take a drink every time the defense used the word palpable. Luckily, she had to bow out early. She reportedly had a hangover from how many times they used the word palpable, and she even missed one of them because she had to leave early. So that's a great little by throwing in the word palpable. Congratulations, plaintiffs, for putting that in there. That's awesome. But one thing they didn't mention here is that to anyone watching the last day of trial, the disrespect towards the court rulings and later the verdict was palpable. What was also disrespectful was the defense's behavior and attitude towards the people during the closing arguments, and especially towards Maya. I think when he was giving that derisive laughter, that scoffing shit he was doing, that made my blood boil so damn much. That, I mean, you have the plaintiffs who are essentially, I mean, they were getting emotional during the closing arguments, and then you've got the scumbag prosecutor. I keep saying prosecutor. I just think scumbag equals prosecutor. Bad idea. Okay, the scumbag defense lawyers are openly scoffing at people. That was disgusting and disturbing as well. Just their overall behavior. Ugh. After the court reiterated it was giving alternative verdict form questions to try to avoid the necessity of a retrial, defense counsel said, "You don't know what the law is." I don't know who said. I don't know which one said that. So it was Mr. Hunter. Okay, so I can't do the voice. You don't. This is the defense lawyer telling the judge he doesn't know what the law is. You don't know what the law is, so you're going to give the jury both options right now? Is that what you're going to do? I'm sorry, I object to that. Then came the following exchange. The court, "I'm just saying, Mr. Hunter, it seems what you're saying and what I'm hearing do not match." Oh, and what I was also saying, Your Honor, was that you're only hearing seconds-long clips. You're not hearing the whole thing. You're not hearing the entire value, and it doesn't sound like you're prepared to listen to the whole matter. This is a fucking ballsy move by a lawyer to call out a judge like this. When you start slinging around accusations that the judge is somehow biased towards another party, or the judge is somehow you're taking a position and is influencing the trial, that is a serious allegation that can get your ass in trouble in a heartbeat, which is why the court says, whoa, time out, because that's a very serious statement you just made. He's giving him his out right here. This paragraph from the court is the court saying, you better fucking think about what you just said, buddy. This is your one and only chance to back away from this, or shit's getting, the tuft is coming for you. The tuft is coming for you, brother. This was his out. Whoa, time out, because that's a very serious statement you just made. Do you really think I'm not making balls and strikes calls? I've just eliminated a couple of items from their exhibits, and I'm listening to your statements. So I just want to make sure, are you saying that I'm closed-minded in this case? That is a judicial equivalent of, you better fucking think about the next thing to come out of that yap of yours. Because it's going to go one way or the other, depending on what you say next. Choose your next words carefully. The answer to that was, Judge, I'm suggesting that on this particular issue, you have indicated a predilection regarding the Heart Institute issue, and I don't think I'm able to get past, and that's my problem with it. And on these particular clips, what you're also seeing once again, and I hate to sound like a broken record, but you've just listened. This is a town hall meeting that went on for some period of time. I don't know how long it was. They've got a whole clip of it. Okay, a whole clip of it I haven't seen, and frankly don't, to this moment, know the entire source of, but you're reacting and visibly reacting to clips from that thing that are seconds long. You're not hearing the whole story, and that's my problem with it, Judge. So he backed off a little bit there. He backed off. Right. Defense counsel Shapiro made the same false claims to the media and the public, stating in a media interview just outside the courthouse on November 1, 2023, that the hospital is credentialed by outside agencies that have found that the hospital has always operated under safe environments. Well, see, again, you use that exaggerated word, always operated, and that opens all kinds of doors when you do it in trial and whatnot. Also, as described in the declarations attached to his Exhibit F and G, defense counsel Shapiro made repeated that was just beyond the pale. Shame on him. That was absolutely conduct unbecoming an officer of the court. Shapiro repeatedly made vulgar remarks while exiting the courtroom in a voice loud enough for everyone present to hear. Gabrielle Carson declaration, Connie Stumpf declaration. Specifically, attorney Shapiro said, "fucking ridiculous" and "fucking scumbag family," where everybody in the hall could hear it. That is so far over the line. I mean, that's grounds to drag your ass back in there and hope to God you don't get a bar complaint, hope to God you don't get disciplined, and hope to God you keep a substantial amount in your checking account. Attorney Shapiro continued uttering similar expletives and derogatory comments as he walked down the hallway where members of the public and the media gathered throughout the trial. Defense counsel's contempt for the jury is also demonstrated by a social media message from another member of the defense trial team and members of their law firm to attorney Shapiro, which included a slur on the jury members as 6 people from the bus stop. Thank you for your continued help. Next time I'm in wherever, owe you one. If your other colleagues have insights, please pass along, specifically on the social media side. At this point, the medical arguments have already been made, and yes, it's a very important case. We'll never stop fighting for you guys. I'm ashamed at the outcome, especially after so many years, but you never know what 6 people from the bus stop can do. Well, tell you what, they are 6 people from the bus stop. They're 6 random people from society. Okay, that happened yesterday. Something just triggered the voice activation on my tablet, which is sitting in my backpack on the kitchen table in the other room. That happened that's weird. And it was right about the same time. I'm going to start keeping it at 1:22 a.m. I think I've got ghostly activity going on here. Anyway, sorry for that weird little distraction, but that happened yesterday. Something triggered the voice activation function. Anyway, as I was saying, the jurors actually are people from the bus stop. They're random citizens taken from the community where you live. They are people that take the bus to work. They're normal people. Taking time out of their lives, taking time out of their day, taking time away from their jobs and their families for 9 weeks to do this shit. They are people from the bus stop. And to make that sound like a derogatory statement, that shows way more about David W. Hughes, shareholder. He's one of the biggies in the firm. He's one of the partners in the firm. Him and his colleagues and Shapiro, whatever. It says way more about them than it says about the jurors. They are people from the bus stop. I almost called him a mother effer. They are people from the bus stop, you dickhead. And that's a badge they should wear with honor. Nothing would be more deleterious to the integrity of the judicial process than to subject people who have done their jury service to a deposition or an interview by lawyers. Yet, right, capable of such. Okay, I didn't even finish the sentence. Let's try that again. Nothing would be more deleterious to the integrity of the judicial process than to subject people who have done their jury service to a deposition or an interview by lawyers capable of such behavior. So yeah, the very people that called them just 6 people from the bus stop, the people that called them that, they want to bring them in after they've done their service and interrogate them this way. Who the hell is going to want to be on a jury if they know that whatever they do, some schmucks from one side or the other are going to call them in and cast aspersions on their character, cast aspersions on them directly, and subject them to interrogations. There can be little doubt that a deposition or interview would be used to further vent defense counsel's frustration and anger on display on the last day of trial. Finally, in regard to the request for emergency relief regarding text messages and other electronic communications of juror number 1 and his spouse, the sole justification offered is the unsubstantiated statement in the motion that defendant has learned that individuals associated with juror number 1 and his wife have begun deleting social media posts. Such statements should be given no weight without further detail and an identification of the source. Exactly. Name the source. Name what's been deleted. And number 2, consider the possibility that when you start rearing your ugly head like this, they're still under no order not to delete anything. There is no court order saying they have to keep everything there. If you're accusing them of doing this shit, if you've already demonstrated you're going to dig 22 years into their past to try to find things against them, if you're making these comments in public, if you're accusing them of wrongdoing, you're clearly plowing through social media. Why the fuck wouldn't they start deleting the hell out of their social media stuff? Why wouldn't they shut it all down? Because they don't want your scummy fingers prying through their internet history. And shame on you guys. Shame on you on the defense. Defendant supplemental motion for a new trial based on juror misconduct, motion for juror interview, motion to open discovery into evidence of juror misconduct, and emergency motion to preserve evidence. Plaintiffs are aware that at 11:45 a.m. on November 27th, 2023, defendant filed this was way over the line. Absolutely way over the line. When they went back 20 some odd years into juror number 1's past and found some bullshit. Plaintiffs are aware that at 11:54 a.m. on November 27, 2023, defendants filed a supplement to its motion, bring in extraneous issues in an attempt to slander juror number 1 further. Plaintiffs do not believe the supplement merits a response, but if the court disagrees, plaintiff requests an extended deadline. The supplemental motion rests on speculation from a matter over 20 years old. Affirming denial of immunity. Okay, this is based on legal experience 17 years before the case. It was another case. Additionally, defendant's supplement asserts that it is reasonable to assume that juror number 1 may have harbored ill feelings towards the DCF, or at a minimum, an allegiance in favor of a party accused of suspected child abuse, like the late Maya Kowalski. The prospective juror questionnaire utilized in this case included the following questions. Have you or any of your close friends or family members had a child sheltered into protective custody by a government agency such as the Florida Department of Children Families, DCF? And do you hold any strong opinions concerning the Florida Department of Correction, the Florida Department of Children and Families, or its ability to take children into protective custody? Juror number 1 answered no to both questions. It is not reasonable to assume juror number 1 had feelings. The defense speculates about when juror number 1 answered no to having any strong opinions. Furthermore, the defendant asks no questions of this witness about any experience with DCF. They saw what was on there. They didn't ask if he had any specifically any experience with him and whatnot. They could have followed up. They could have asked any questions they want of any juror they wanted. It was love at first sight for defense counsel and juror number 1. They didn't ask a single question about the witness, about any experience with DCF. So they're saying, hey, he's on here because they loved him. We liked him. They loved him. He's here. As shown above, the post-trial allegations are irrelevant, and defendant is in no position to complain about impropriety. There's another case affirming denial of a motion to remove a jury for misconduct based on movement claim of the appearance of impropriety. As shown above, the post-trial allegations are irrelevant and defendant is in no position to complain about impropriety. Wherefore, plaintiffs JHACH Kowalski, individually and on behalf of his child, Maya Kowalski, a minor, and as personal representative of the estate of Maya Kowalski, deceased, respectfully request that this court deny all relief requested in this motion. And then we have about 90 pages of exhibits, which we're just not going to get into today. I'll read what I think I'm going to do is maybe schedule a stream to go through the affidavit of Shapiro that was attached to the defendant's motion that we were going through the other day, and there's 3 affidavits, I believe, that are exhibits in this. We just might have an affidavit reading day. But well, there. Hang on here. No, I don't want to save it. I want to close it. Stop. Go away. No. Right, there we go. Let's stack our cams here. There we go. Dog goes to sleep. That was a near perfect brief. That was gold. That was solid. That was some of the best laser focused legal writing that you will see. That's some of the best I've seen in a long, long time. The motion was absurd. And as you saw, Megan, me, Rob, Kurt, Peter, everyone that covered this motion universally and without exception found it laughable, found it absurd. And after I said I discovered that Reddit group, and I was reading through, and they were butthurt. They were absolutely butthurt that every single lawyer that was looking at the motion found it laughable. They couldn't understand how there wasn't a single lawyer that reviewed that motion that sided with them. We're all biased. Every single one of us lawyers that looked at this motion are biased, and we're biased and are just blinded because we hate the hospital. Yet there's not a single person, there's not a single lawyer they can point to other than the defendant's own lawyers that thought that was a good motion. Yet they were damn near traumatized by that. Oh, Hippo lover likes strawberry. Yeah, Yoda's pretty cool too, but Yoda usually goes and sleeps off on the sofa during this time here. Yeah, oh yeah, the basement dwellers were serious mad. And it's like I said, after when Megan and I were doing our motions, of course they didn't like our motions, but it was basically about Megan and I suck and we're the least qualified people to talk about it. That was about 1/3 of the people. The other third of the people were just they were just like full on mode, and the other third were just confused. Nobody on Reddit had any good arguments against what we were saying or against what the other lawyers that reviewed it were saying. I don't know why people are so blinded to considering that maybe this shit actually happened. I don't get it. I mean, just all I know is you look at these motions and you can see the motions match the temperament of the defense. I mean, let's say we look at the defense's motion. They're bitter, they're nasty, they're full of sarcasm, they're full of demeaning language, they're full of baseless accusations, they're just full of scummy, borderline unethical behavior. You look at their witnesses were all scowl-faced, angry people that nobody liked. You look at their presentations, they were dark and gloomy. And you look at the supporters, they're the same way. But then you look at the people that, whether you were on the hospital, whether you were on Maya's side from the beginning, whether you were neutral and went over that way at the end, or whether you came late to the game, the people that tend to agree with the verdict, with the decision, are generally, they seem to be good, happy people. You look at the witnesses, the witnesses that the plaintiffs put on. A lot of them were happy, smiling people. You look at the lawyers; they have a great sense of humor. Listening to Mr. Anderson laugh is one of my favorite things to do now. He has such a warm, open, honest laugh. But then you look at Hunter and Shapiro, and you actually have to wonder if they've ever laughed in their life, ever. And it comes out in the motions, it comes out in the arguments. And as I've said repeatedly, and this is probably one of the last few times I'll be saying it, you just, as a lawyer, as a professional, as an officer of the court, you have to be able to look at yourself in the morning. The 144-page motion, as I said earlier, absolutely within their rights, if not their obligation, to make all of those motions, to renew the directed verdict, to have a new trial because of judicial errors, to have a new trial because of improper awarding of damages, the motion to have the judge as a last resort unilaterally fix the amount. Those are essentially the post-verdict motions that you have to file. It's just a matter of course. But this shit that we read today, the response that we read, the original motion alleging juror misconduct, that's unnecessary. That's wrong. It's just icky and dirty. And then when you go to supplement it with bringing up this crap from over 20 years ago that never went anywhere at all, that's just dirty. That's just dirty to try to smear where there's no smear, to try to drag someone's name through the dirt, to try to sully someone's character. How do you look at yourself in the mirror? How do you look at yourself, pat yourself on the back and say, man, that was one of the best motions I've ever written in my life. Every motion you write, every submission you make as a lawyer, you should be saying, damn, that was the best I could do. I'm proud of what I'm submitting to the court. I'm proud of the arguments I make. I'm proud of the way that I am representing myself through the written word. I don't know how, with that motion for a new trial based on juror misconduct, and especially the supplement, how anyone could say they were proud and felt honored to write that brief. I know they're never going to see this, but shame on you guys, really, for doing that. All right. That's about the end here. Let's go through the remaining super chats and we'll call it a night. It's getting to be almost 2 a.m. over here. It's sad to see that, because that's what makes people hate lawyers. I mean, we roll with the punches, all the lawyer jokes, all that kind of crap. We roll with it, and we even tell good lawyer jokes amongst ourselves. And I mean, it's the old saying, everybody hates lawyers until you need one, then they're your best friends. But it's things like this that unnecessarily give lawyers bad names. And it's just sad to see. Just, I don't know how they live with themselves after writing that, but it's not my problem. It's something they've got to live with. Congratulations, guys. Sullying your name. Boosh McFadden, Legal Vices. Did they bring up any of this during the trial or just after? And that's part of the problem. That was like the very first sentence of this motion was, you waited until after trial. You knew about this before the verdict. But you waited until after to bring it up because you were waiting to see if the verdict was in your favor. You lost, so now you're bringing it up. Sorry, too late. You should have brought it up before the verdict. As soon as you found out about it, you didn't. Therefore, you lost the ability. It's waived. It's done. You've accepted it. Time's up. Too late. Unhung here. Oh, we got to do the big old foghorn for the final round of supporters. Oh, thank you all so much. Okay, I see you there, Megan. Will do. We'll redirect you to Megan over here. All right. Unhung hero. Too many billion-dollar court bootlickers on Reddit. But why? That's what I don't get. Why? That's I don't understand. Hempland, Texas. What's up, girl? Hempland, Texas. Defense needs to stop worrying about Maya's trial and work on the next one that we know is coming. Yeah, there's another very similar case coming down the pike. So brace yourself, lube up, and get ready because there's another one coming your way, JHACH. Rogue Mama, new member. Oh, Rogue Mama, thank you so much for becoming the newest member of the Vice Squad. Everybody wants to be my member. Everybody's welcome to my member. You're all here. Thank you so much. Boosh McFadden, Legal Vices. I didn't hear it until you mentioned it because I wasn't really paying attention, but he did it all the time. They're Mexican, scoff. Yeah, he did. He was a big thing. It was so disgusting to watch. Brandon Lesko returns, the return of the Lesko. Thank you so much. YouTube says, no funny supers. Can you be a bro and redirect to Nicholas when you're done to get him some likes on his stream? Love, Brandon. Oh, dang it. I just promised Megan. I will do it tomorrow. I'll make sure he's streaming. Somebody remind me if I forget. We're going to redirect to Nicholas tomorrow. So that keep that in mind. Please remind me if we. I'm now promising Brandon that we'll pop on over to Nicholas tomorrow. We'll bounce over to Megan today. Okay, all right. Esprit Flick, you're right. No lube for JHACH. They don't get lube. Just bet it's coming in dry. Thank you very much, Brandon. Let's go returns. Just for you, Brandon. Let's go returns. We'll do Nicholas tomorrow. Whoa.
Hey, phrasing.
We'll redirect to Nicholas tomorrow. That's what I meant to say. JKD Buck 76 member for 8 months. What you gonna do when Tough Mania? What you gonna do when Tough Mania comes down on you, brother? Had to read the whole thing to know the voice I was supposed to read that in. But that sounds almost like my Randy Savage voice. It was pretty close to Duncan, Idaho. I want everyone to visualize a close-up of Shapiro's mouth as he repeats in Shapiro voice, palpable, palpable, palpable. Emperor Palpable-Teen. Torin 3 with the $5. Thank you so much, Torin 3. My creature comforts are curling up with a good book and braiding on my takadai. Thank you so much for that, by the way. He's working on a traditional Japanese braid for me. Can't wait till it's done. That's going to be awesome. Thank you so much, Torin 3. Unhung Hero. Clearly, reading on Reddit is a pretty good indicator of how miserable these people are, especially in defense of government and billion-dollar corp. And Brandon Lesko returns. I feel ignored and rejected. No. I was just a little bit delayed, but we'll pick him up. We'll pick up Nicholas tomorrow after O.J. Simpson. We'll pick him up. Do they have a criminal case against these civil or criminal case against these lawyers? Unfortunately, not really. Ethics complaint, maybe. But I mean, there's kind of the immunity they have to make their arguments. They're just dicks for doing it, basically. Well, I think this brings us to the end of our little show here today. Whew. That was a great motion. That was a great motion. Very, very well written. Very, very persuasive. Very, very concise. Although it's odd to call a 40-page document concise, but that was concise. There was not a lot of pork and extra fat in there. That was a good, focused brief. No, don't leave. I have to leave. It's time to go to beddy bye for me. So, almost 800 people liked. Woohoo! Give it a whirl. All right, so we've currently got 921 people, 791 likes. We're like 200 away. We can get 200. We're going to be doing this for about 2 more minutes. We're going to shut it down in about 2 minutes. During this last 2 minutes, of you 913 people that are still here, 200 of you need to get over there and hit that like button. Let's see if just for shits and giggles, we can bring this thing up to 1,000 likes. And if you haven't subscribed, I would ask you kindly, from the bottom of my heart, honestly, openly, to please subscribe to my channel, give it a shot, give it a whirl, as Elaine would say, and come back for more, because this is the stuff we do here. Tomorrow, Thursday, is O.J. Simpson Day. We're going to be doing our O.J. Simpson retrospective. We're watching closing arguments. And in a couple of weeks, we're going to move on to a new trial. Friday, we're going to be watching some updates in the Alex Murdaugh trial. Some big developments there. We're going to check that out on Friday. Next Monday is going to be a Maritime Monday show. Not sure what exactly we're going to talk about yet. And next Tuesday will probably be another YNW Melly motion update regarding these 7 additional charges of witness tampering he's been charged with in his double capital murder case that's coming up for retrial soon. All right, let me set this for a redirect to Nicholas tomorrow and Megan tonight. Caught myself there, didn't I? All right. Let's see. Go into my studio. We'll go to Megan tonight. Then we will go to Nicholas tomorrow. Somebody, please, is going to have to remind me to redirect us to Nicholas tomorrow. All right. Hang tight. Going into YouTube Studio. Going into content. All right. Today's show. Into customization and redirect. And let's see if we got a Megan Foxicle in here. Megan, I don't see Megan's stream set up. Uh-oh. Megan, you better be set up. Search for it, Megan Fox. Oh, it says upcoming. When is Megan Fox upcoming? Megan, when are you upcoming? Bear with me here for just a quick second, peeps. 2 a.m., 10 minutes from now. Okay. She's going to be going live in 10 minutes. Megan, if you're watching, you should probably start a little bit early. All right. That's it, ladies and germs. We are here. We have come to the conclusion of our day. Let's see if anybody, we got 837 likes. Well, we picked up an additional few. It'll probably turn into 1,000 overnight, but thank you everybody that was here today for this motion. Don't know what's coming up next week. Like I said, in a couple of days, we might do an affidavit reading for some of the affidavits that have been attached as exhibits that we haven't looked at. Stay tuned for that. That could happen early next week. We'll just see how it goes. Thank you so much, mods, for being here and doing all the moddy things. All right, Megan Fox says she's live, so we're going to head on over there. Thank you, mods, for being here, doing all the mod stuff. Chat, thank you for being here. You are the greatest chat on the entire internet. Thank you to all of the other people that are here for the first time, to giving me a shot, seeing what I'm offering, and I hope you enjoyed it. Thank you to Juror Number 1, Mrs. Juror Number 1, Jules, Rob, Kurt, all the other law tubers and interested people that were here in chat. It was good to see you. Appreciate all of the support through all the super chats, memberships, the monthly membership chats, and everything. Thank you. Thank you. Thank you. We'll see you all here tomorrow, hopefully, for O.J. Simpson. Closing arguments. Until then, take care of yourself and whoever you're with, whatever you're doing. Just make sure you enjoy your legal vices. Law Rex, saying peace out.